Good morning, everybody. Time for the inquiry to resume, the last day of this week. I just want to do a quick catch up on certain documents at the beginning of the day. And the first one just concerns my reminder about the location plans. And I think that's been agreed. I've had an email sent to me via the office from the local planning authority, which confirms the revised plans that came in from Mr. Rowe. And Mr. Rowe has emailed in to signify his agreement with that. So I'm content with that. So thank you very much for sorting that one out. In terms of identification of the appeal sites, that was just a query in relation to sites A and B. I've had an email from the local planning authority which says that the access track which we've been talking about during the inquiry now has a name, an official name, and it's called Crocus Lane. And that the sites A and B on the sites opposite them also have official names too. In that site, to the south of site A, the land there is known as Weeping Willow, and further along, when you get to site B, the land opposite is known as Ranch Park. So the council's suggestion is that site A should be known as land north of Weeping Willow, Crocus Lane, and that B should be land north of Ranch Park, Crocus Lane. Now, there's been nothing back from the appellant's agent, but that seems to me to be a reasonable suggestion. I mean, Mr. Woods, are you able to indicate whether you're happy with that or not?
Yeah, yes, I think that's fine. So it seems sensible.
Yes, I think so. Makes it clearer.
It does, yeah.
Thank you very much. Then, in terms of the site visit programme, the council have sent in a revised plan because I think there was the wrong route adjacent to the sites had been shown on the original plan, going further down into Lydia Park rather than along what's now known as Crocus Lane. So I've got that. I've got no comments from the appellants as yet, but the suggested date was Monday.
Yeah, I haven't seen that yet, sir.
Okay, that's fine, Mr. Woods.
So if I can ask Mr. Bennett if it's possible to print out a copy for me, and then it'd be easier to mark anything. Thank you.
I just had a couple of thoughts on that. One, it's essentially a circular route going along Dunsfield Road and then up towards Hascombe Hill and back to down towards the site. There's suggestion that we go to Thatched House Farm. Now, according to my ordnance survey plan, there isn't a right of way there, a public right of way there. So I'd need to check that has been arranged, that we can all get to Thatched House Farm.
Sir,
I'm happy to do that.
yes, I can supply you with an email from the owner.
I don't need to see anything in writing as long as it's been sorted out.
It has been, yeah, certainly consent from the owner has been given.
Thank you. I'd also like to go up Stovolds Hill to when you get to the end of Crocus Lane, to turn right and go up in that direction as well as part of the site visit. Just I think there are a number of properties down there, and I'd just like to be clear in my own mind about the relationship between those and Lydia Park. And I did wonder whether the route as I can see it seems to cut across from west to east below the top of Hascombe Hill. I'll leave it with the parties to think about. I just wondered whether there was any advantage in going to the top of Hascombe Hill itself. I think there are paths up there, but I'll leave that thought with you. Conditions, the council say that's in hand, and that's fine. As long as I can get something for Monday, that would be useful ahead of what we're going to talk about next week. And then just a couple of other things that haven't been raised by me in the same way, but one cropped up yesterday, I think, and that was the existence of a tree preservation order on one of the sites. And I agree if that's the case, we need to know about it, but that needs to come in as soon as possible, please, and be added to the inquiry documents list. And then core document 6A.7, which is in the policy section, and it's part 2 of the local plan. And the one I can access has a watermark saying it's a draft version. And there are, I know a lot of these sections repeat themselves for appeals B, C, and D, and I haven't been through them all. I'm presuming it's the same situation, but the local plan has been adopted.
Yeah, we will make
So-
sure 2023
Yes.
inspector is when it was adopted.
Yes.
So we'll make sure that a version
needs to
is
be the
put
correct
in,
version.
which says it's the final version. I agree.
And then again, I don't know whether my system's just a little bit slow, but I don't think that the inquiry document section is right up to date. And I know there have been things going on, but I couldn't see the email exchange that was referred to a few days ago in there. And then I think there was an extract from the PPGs that the appellants put in as well, but they need to go on.
The document exchange is in the existing core documents, but
Right.
it just wasn't possible for.
It just couldn't be.
It just, yeah, Mr. Cuttle just wasn't able to identify it, and we couldn't immediately find
Right,
it.
so it is there.
It is there, yeah. It's in the appendices to the council statement of
Thanks,
case.
Mr. Lintos.
It's actually the addendum state of case. It's CD4B.3, and I'm very grateful to the planning authority for helping me find that.
Right. Okay, thank
The
you.
Surrey Wildlife Trust, while I've got the mic, is CD12B3, which was the Surrey Wildlife Trust.
Right, so
response.
perhaps we're there.
I also would like to ask Mr. Ward about conditions from the PPG, and I'm not sure, I wasn't envisaging the need for that to go on the website. But like Mr. Masters, I'm going to be referring to particular paragraphs from the PPG on the negative Grampian with Mr. Ward.
Yes.
I don't know whether you need copies of that to go on.
I'm not necessarily persuaded that it needs to go on. I mean, if a document's handed in, I'd like it on the in the core documents library, but I can access it in any event, and I'm sure the parties here today can.
I'm sure we can, but just
Yeah.
just in case it's quicker, do you have copies of it to pass around or not? Okay. Right. Okay. Well, just in case, just email it. Yeah, email it to me and whatever contact you've got at the council in case.
Okay. And
Sorry,
then, sorry, Mr. Masters.
Sorry, I didn't. I wonder if I could just clarify. So you asked Ms. Mercer certain information yesterday. My note in relation to the flooding.
Yes.
My note is that you wanted the dates of all relevant national and UK flood mapping that has been relied upon. I've got it right. 2, the dates of the information, i.e. LiDAR, on which mapping was based. 3, the identification of the categories shown. 4, what those categories relate to.
Yes.
And 5, information on debts if available, attaching all relevant attachments. Have I got that right, sir?
I don't think I asked for attachments. It was just essentially a short note covering the 4 points that you mentioned.
Yes.
Yeah.
Thank you, sir.
And then I think, Mr. Masters, you were hoping to put in some documents today concerning personal circumstances.
I have, sir. I noticed you said yesterday as providing they were there on Tuesday,
Yeah.
it would be okay.
Is that the intention?
Is that's the intention? I didn't prioritize
No, that's
trying
okay.
to photocopy them because that was the case till Tuesday.
Just 2 other things. We're hearing from both the planning witnesses today. Now, the proofs, I think, particularly Mr. Wood's proof, cover other areas that we've dealt with in topic sessions at this inquiry. So there's no need to repeat and go over ground concerning landscape, flood risk and ecology. I appreciate that they're obviously covered because you deal with the planning balance, but what I don't want to rerun a set of arguments that we've already had and discussions that have taken place. And the final point is I do need to close things down and adjourn by no later than 5 o'clock. Okay. Mr. Cottle, did you want to raise anything?
No, no, only that we will be quite pressed because I'm looking at Mr. Ward's evidence and there's quite a lot of it. And without going over the ground, he begins with, for example, over domination and issues that haven't been touched on
Yes,
by the
I appre-
previous witnesses. And there's quite a lot of
I appreciate
information.
they need to be covered.
My cross-examination, I'm confident Mr. Masters will do a lot, but I've got a lot of questions that I'm going to tick off when Mr. Master goes through them. But if he hasn't gone through them, I'm going to want my hour.
Mr. Masters, have you anything to raise?
I haven't, so sorry, no.
Mr. Lintodd?
No, Inspector, I mean, I will move through it as a quicker pace as I can. Obviously, I will only ask for things which we've dealt with insofar as they have an impact on policy, planning policy, and
Yes.
concentrate on issues we've not dealt with. In terms of the PPG on conditions, I've got that obviously online, as have you. I'm sure Mr. Ward will as well. Given that we haven't got that in any evidence at the moment, if Mr. Cottle could indicate which paragraphs in relation to the PPG he particularly wants to rely upon, and then we can all have those in mind.
006. Particularly 09 and 10.
Yeah. Brilliant.
Okay. Right then, Mr. Lintodd, would you like to introduce Mr. Ward, please?
Yes, and Inspector, given what you've said and given where we are in the inquiry and given the grey in Mr. Ward's hair, I'm not going to ask him to go through his experience and related personal information at the beginning of his proof. That's there for you to read. I'm just going to, at this point in the inquiry, go to topics as I have done previously with the witnesses in chief. And I'll give you an indication of what those topics are so you can see how we're faring as we go through the examination in chief and get a feel for how close we are to the end. So that the first one, I'm just going to ask him to help us with what the conclusions on landscape mean in terms of spatial policy and concerns of valued landscape and national landscape. The second issue is impact on the settled community. The third issue is in respect of flooding, only where we are in terms of the sequential test following the cross-examination and your questions of Mr. Woods, insofar as it's dealt with by Mr. Ward in his evidence, and then the exception test only insofar as we've got the community benefits section, which obviously is a planning matter. In respect of issue 4, that's sustainability, very briefly, but only in relation to whether that's a matter of any weight in the balance. The fifth item is intentional and authorised development. The sixth, very briefly, on best interests of the child. And then it's the planning balance where we stand at the moment. And so, good morning, Mr. Ward. If we can just start off then with that first issue, which is the conclusions on landscape or the evidence on landscape, where that leaves us in relation to whether the development complies with the spatial strategy. And I've particularly got in mind, we've got policy AHN 4, and rather than ask you to read what that says, it's common ground and it's in all of the documents that we've got within the second part of that policy AHN 4. We've got 2 considerations that relate to the site not having an unacceptable impact on the physical and visual character of the area, and also the proposal according with other policies in the plan. So in respect of those elements, obviously we've had lots of evidence on landscape views and all of those things. What I want to ask you is firstly, under this heading, what's the consequence of Mr. Dudley's analysis in respect of valued landscape in terms of how the inspector needs to treat this issue in a policy context, please.
Well, clearly, given the policy context, we want the impact
Just make sure you've got your, because I may have cut you off there, so put your, bring it as with all the others, we bring
Yeah.
it right close to you. That's it.
I've got the problem of the air conditioning noise right behind as well, so, yeah.
Do I need to repeat, or did people hear that first bit?
I would start from the beginning, yeah,
Start again.
just.
The issue is, given the context of policies RE1 and RE3, RE1, the impact on the countryside, RE3, impact national landscape in AGLV, then clearly if either of those harms exist, then there is a conflict for the spatial strategy in terms of those two policies. By default, then through AHN4 as well. Now, I've set out those policies in section 5 of my main proof. I don't need to go to them today unless you need me to. In terms of RE1, there is a need to determine if development would safeguard the intrinsic character and beauty of the countryside. And in terms of RE3, there's a need to assess whether the development, in this case, which is outside the national landscape, will harm public views from or into the national landscape, and separately, whether this will be harmful to the AGLV, both in its own right and in terms of the purpose of the AGLV as a buffer to the national landscape.
In terms of policy then, what does both the development plan and the framework tell the inspector that he needs to do in terms of, well, both of these considerations, valued landscape and national landscape?
Well, the guidance in terms of policy in the MPPF comes in sections basically in chapter 15, but the key policies being or the key sections being paragraphs 187 and then 189 of that document.
And so dealing with valued landscapes, I don't want to teach the inspector to suck eggs, but just refer him to which bit it is and what the consequence of Mr. Dudley's conclusions are in respect of that then, please.
Well, in terms of 187, the requirement is to enhance the natural and local environment by protecting and enhancing valued landscapes. So to protect and enhance, and also to recognise the intrinsic character and beauty of the countryside. And then what 189 tells us about great weight to be attached in terms of national landscapes.
And what
The
about
further part of
Yeah, go on, sorry.
189 then advises that the setting of those landscapes should be sensitively located and designed. Sorry, applications affecting that within the setting of those landscapes should be sensitively located and designed.
Thank you. And then in terms of the conclusions of Mr. Dudley, in terms of, in particular, Mr. Willow's decision at Burnt Hill and those conclusions, what do you say about whether or not those policies are complied with in this case?
Well, Mr. Dudley sets out his appraisal of a landscape and sites within the national appeal sites within the AGLV. He explains that is by definition a valued landscape which is required to be protected and enhanced. That's where he refers to Inspector Dudley.
Inspector Willows, yeah.
Sorry, Inspector Willows at Burnt Hill. That's in paragraph 215 of his proof. I don't know if you want to take me to go to that particular decision.
No, that's fine. Just to help the inspector with where we are at the moment in the.
But the decision is that in Dudley's Appendix 16 and the relevant paragraphs for now paragraphs 47 and 48.
Now, I'm conscious of time and what the inspector's said, and Mr. Dudley has given a lot of evidence. I've seen the inspector taking a careful note throughout of all of that evidence. And you'll recall, as I do, Inspector, Mr. Dudley addressed things such as the appearance of caravans, whether they're acceptable within the particular landscape context, and the relevance of Lydia Park in this case, in respect of receptors and those sorts of things, and also the effectiveness of landscaping. I'm not going to ask this witness to go over all of those matters because those are obviously all detailed matters of landscape policy, and Mr. Woods has already given his evidence on that, and you've got your notes on that. But I will just ask the witness to deal with one additional thing. He's dealt with national landscape and Mr. Dudley's conclusions on that. Inspector, for your notes, they come in, for example, CD 8B.2 at 4.27 to 29, where he deals with impact on national landscape. So I won't ask the witness to rehearse those, but I will ask the witness just to deal with one element of that. So we've gone to 189, and we've seen that the end of 189 tells us in terms of national landscape that the scale and extent within areas such as these should be limited, but development within their setting should be sensitively located and designed. Now, Mr. Dudley obviously deals with that, but from a planning perspective, what I want to ask you is, given the comments that Mr. Dudley makes at his 4.27 to 29 and the conclusions that he reaches in his landscape evidence, what do you say about paragraph 189 in the context of footnote 7 to the paragraph 11 of the MPPF, and whether it's a strong reason for refusal?
Well, Mr. Dudley clearly draws the conclusion that the appeal proposals are not sensitively located and designed. He refers, I think his phrase is to the elongated rectangle of development that extends towards the national landscape and the impact that has on character. So he is critical that the appeal schemes are not sensitively located and designed. And in that context, clearly there is then a conflict with paragraph 189. And because that is a topic to which great weight should be applied, just rehearse the wording, but basically then in the context of policy 187, that is a matter which would, if I can paraphrase, effectively disapply the tilted balance.
So you said
So
187 there, yeah.
11D is not engaged.
11, that's the 11D, yeah. And we've already dealt with under 187 what his conclusions were in valued landscape terms. So what I'd like to just ask you then is just to summarise on, and again, Inspector, we've had a lot of evidence on the views that you can get from the site, the winter views, the summer views, how Mr. Dudley has assessed those, combining sensitivity and magnitude of change. I'm not going to ask this witness to rehearse any of that. That would just be taking up time that we need for other things. And you're going to, and you just indicated actually on your site view, you'll be looking at all those factors anyway. But what I do want the witness to say is, well, given what Mr. Dudley has concluded in respect of essentially those three elements, the landscape character, the national landscape and the views, particularly bearing in mind what you said about national landscape and valued landscape, where does this leave us in terms of that first issue that you began with, the spatial structural policies within the plan, whether or not we've got the council's spatial strategy within AHN4 complied with in this case?
Well, very simply, there is a breach of those policies and therefore it's not in compliance with the spatial strategy.
All right. And so we come on, Inspector, to impact on the settled community. And I want to do this, Inspector, in relation principally to two documents. One of them is the Inspector Gilbert decision, where she at CD 3A.8 addresses this specific issue. And one of them is a document we've not looked at yet, Inspector. It's a document you can find at CD 10A, Roman numeral 2.1. And that's Mr. Wood's email that he put in at the beginning of the year. And he attached a decision, which is a decision 00451. So it will be those two documents that I asked the witness to turn up to address this issue. Yeah, I'll give that reference again. So it's CD 10A, Roman numeral 2 in brackets, point 1. No, that's the one which is the Mr. Woods's email. The Gilbert one is at CD8, CD3A.8. Gilbert. Mr. Woods's decision isn't an inspector's decision. It's a council report that he put in attached to an email. So that's not an inspector. All right.
Sorry, could you just get, so I can find them. CD 3A8 is Gilbert's. CD 10A,
CD 10A2.1 is Mr. Wood's email and attachment. And the attachment is the one he identifies in the email, which is the decision 00451.
and this is a council planning decision,
Yes, yes, it's an officer's report.
an officer's report.
Helpful inspector, it's the only document within that bracket of decision of the core documents bundle.
And give me again, which core documents category are they in?
So it's in your one, actually, A.
Hey, thank you.
Yeah. Yes, the Gilbert one. CD3A. 0.8. Brilliant, excellent. Thank you, Inspector. So you'll see there, Mr. Woods, that turning first to 3A.8, we've got under issue B, what Inspector Gilbert defines as the effect on the settled community. And I just want to explore with you the principle that Inspector Gilbert is applying there, and so that the inspector can see the application of that principle in the case that's before him. And in respect of that principle, we can see there on page 4 at paragraph 20, this is really where the ratio of what she is saying in relation to this issue is laid out. And what I want to ask you about is within that paragraph on page 20, starting the proposal would provide a home for members of the same family. We see there that she goes on to talk about the numerical side of domination of the nearest settled community and the spatial side of it. And she deals with those two as those two considerations in that paragraph. And she ties that paragraph back also to the other paragraph I'm going to ask you to refer to on the previous page, which is paragraph 13. And what I want you to do is to help the inspector with what the position is in terms of the approach he should apply numerically and spatially, and what she found to be significant, if anything, about the relationship of the site that she was dealing with that issue. So can you help the inspector with that, please?
Yes, well, very briefly, the inspector heard evidence on both the number of gypsy and traveller sites and the number of houses in the local settled community, noted that the application represented an increase of 4 pitches. And that's a numerical increase, but then importantly looks at the fact that it was also a spatial extent, a spatial expansion of Lydia Park, and that, or in the words of in paragraph 20, spatially the extent of land occupied would also increase. The rationale behind that is set out, well, in general, but particularly in paragraph 13, where she's looking at other sites which have received permission to the south, so perhaps being asked to consider the similar issues that Mr. Woods has raised, but comments that the sites to the south, and this is the second part of paragraph 13, the sites to the south would have a smaller and generally rectangular pitches with limited landscaping, while they would be likely to be more intensively occupied, so potentially the numbers would be higher due to their size and layout. Their infill position to the south of the track within the established area of Lydia Park fundamentally differentiates those sites from the proposal before her. So even though the sites within the confines of what we're calling Lydia Park, the area to the south of Crocus Lane, might lead to a higher numbers, spatially they would be less significant and seen less of an increase than sites to the north of the track.
So before I'm going to ask you to go to Mr. Wood's rebuttal email, because that's a useful link to go between the documents, bearing in mind it takes a while for us to move between documents, I think it's probably also helpful if you deal with the other element within this decision that you're going to consider, which is the nearest settled community, because it's something that this inspector looks at also. So before turning to the next CD, can I just ask you to have a look at paragraph 19 in relation to that issue and what this inspector is considering when she's considering the settled community and the impact on it. What's she looking at in paragraph 19 is comprising the relevant nearest settled community?
Well, clearly in paragraph 19, and I think I referred earlier, but she's referring to the local settled community, consisting of, I think elsewhere it says approximately 20 houses, or some 20 houses in the nearby hamlet on Stovolds Hill and at Thatcher's House Farm. So Thatcher's House Farm is grouped with the other houses on Stovolds Hill.
Now, Inspector, we'll come back and look at that a little bit later on, but I wanted just to give you where she deals with that in the document. And now we're going to go to document CD 10A 2.1.
I was just going to say to the inspector, I think from that point of view, your comment to take a walk up Stovolds Hill is useful. It's probably 10 minutes in each direction, but the settlement or the group of houses there is a very scattered group of houses along that road.
Excellent.
I'm sorry,
Yeah, good. Let's go to 10A 2.1 then, and the rebuttal email Mr. Woods has put in.
Oh, sorry. This is the officer's report.
That's right.
Referred to or attached to that document. Yes.
And in terms of where, Inspector, you find the issue within the report, I'm sure you'll have the PDF page open. So it's page 11 within that CD reference. And just let me know, Inspector, when you've turned that up. Page 11 should have in the middle, 2/3 of the way up the page, a 12 domination of the settled community.
Page 11, this is the.
Yes. So it's PDF page.
I've got it, I've got a hard copy, but it's on page 6 of my hard copy, so
It's what, well, I find that odd because Inspector, you're in CD 10A 2.1. So that, can I just check with you? So that starts off with an email starting, "Dear Alison, the appellant's position." And that's the email. Yeah. So that's page 1. Yeah. And there's an and there's 5 pages of the email, and then the document starts the attachment on page 6. Oh, I see. Right. Well, that's okay. So, well, but you've got the attachment, which is the one starting 0451. So if you scroll through, Inspector, or for me, it's PDF page 11, but if you scroll through 5 pages, you get to the, yeah, different headings of numbers. That's right. So just go through to 12. And so you've got policy C of the PPTS state.
Stage, if we're talking about particular sites, just so that I've got my bearings on this, is there a plan, Mr. Ward, that you can identify what the one that's being talked about here?
Yes.
You've got several plans in your
no,
appendix.
no, I can take you to one. I'll just,
I've got hard copies of your original appendices. So
I've
that will be
got hard
quickest.
copies. Just trying to think which one it is. Yeah, I'll just check this in a minute, but I think it's CW 7A. So it's my appendix 7. And that's the one that went in with my proof rather than the council's initial appendices. 7A is an update, obviously, of an earlier plan.
I've got the original one, the coloured one. So
I've got coloured copies of both, so.
So, Inspector, if you turn to the supplementary evidence of Mr. Ward, if you've got that printed out, you'll see that came with a series of appendices. And there are
yeah,
5 of them. Yeah.
yeah,
And it's the first of those appendices that are attached to that.
right. 7A.
If it's easier for you, Inspector, because you want to have open that page as well as the new document, and I can see you've got next to you a hard copy of the original
I
appendix.
have, yes, I've got the
So
original, but
if-
Mr. Ward's 7A.
It's where it's both 7 and 7A, but we would need to point out. Yeah, we need
Tell
to
you where it is on 7, if
but
that
it's
helps.
not-
That would help enormously.
Yeah,
It's
not
just
like-
7A actually has got it
It's got its marked. So
marked on.
on 7A, it's actually written in there and with an arrow pointing to where that planning application reference applies to. But if you look at 7, you've got the same plan, and Mr. Ward can point to you the triangle of land that applies.
Well, I can either point it to you or it should be clear if you kind of count from right to
Right to
left.
left, yes.
So you've got the large site on the corner, you've got a rectangular site next to it. You've then got the long site with various pitches marked on it.
And that's
then
the
you-
one 516, the long one with the pictures marked on it.
Yes, I can see the number for that,
And
yes.
then you've got a triangular site next to that.
Yes,
Which
that-
hasn't got any permission at that stage, but is now the one that is 00451.
That's the one.
So it's that triangular one with the
Thank you,
broad,
that's very
the
helpful.
base of the triangle
Yeah.
towards Crocus Lane.
Thank you.
Brilliant. Good. So I'm sorry to make you go out of
No, it's
the
okay.
previous one, Inspector.
Right,
Brilliant.
we're in the officer's report.
Excellent. And you've got, what the computer does is it keeps, if you're on one page in a particular appendix, it takes you back to that page. So hopefully it's taking you back to
It
the same
has,
page.
yeah.
Brilliant. So, Mr. Ward, if you could then take us through applying the principles that we've discussed, can we have a look at how the local planning authority has addressed this site within this section and explain to the inspector how that's relevant to the test that he's applying as you go through, please?
Well, crudely, most of the paragraphs in that section are relevant, but kicking off with the first one below the italics, it refers to the existing gypsy and traveller settlement to the west of Stovolds Hill, comments that it already dominates in spatial terms. It then, next paragraph starts this application, but explains that it represents infill development situated between the existing gypsy and traveller sites. Crucially, it does not extend the physical envelope of the settlement to the north or encroach further into open countryside. It does not impinge on the land to the north where no planning permission exists for residential use. And then in the next paragraph, whilst it would represent a modest increase in the population, reference to the PPTS and the primary concerns of scale of development and spatial arrangement, the proposed, and at the last sentence, proposed development does not extend or exacerbate the spatial boundaries of Lydia Park and does not contribute to any additional physical or visual dominance.
And so when it talks about the principles to apply, and in particular in that third paragraph where it talks about the spatial arrangement of the site being the key determinant, how do you read that as tying back into the principle that Inspector Gilbert has identified? Is it consistent with that or inconsistent with it?
It's consistent and possibly, or quite probably follows on from what Inspector Gilbert said, that her concern related to the spatial, in terms of dominance, represented a spatial increase in size.
Yeah.
The distinction and comment in passing is clearly there is reference in there to the impact on that and views from, in that case, Stovolds Hill. For clarity, the council is not suggesting that the appeal sites would have any impact directly on Stovolds Hill, but instead there is an impact on Dunsfold Road and potentially other locations.
And we've got the various footpaths and things that you've referred to
That's correct.
previously. So, and also, can I ask you before we move on to the next topic, then, just to finish off on this, you've got some aerial photographs, I think, within your original proof of evidence. And can I just ask you to turn up two of those, really? I think CW3 and CW5. So CW3 first, just so the inspector can see the point you're making about the difference, if any, between the appeal sites and the rest of the Lydia Park sites south of the access track. So we've got
Well,
CW3
three, I think
first.
we've got a number of aerials, but and accepting there is some bias in that photo due to the camera angle and three, and it's a nighttime photo, but that photo shows very clearly the fact that the appeal sites are all in the only development that's extending out to the north of that access track.
And then what
More
about
representative photos are probably shown in CW5, but again, they're a series of daytime images from various angles, but show the appeal sites very clearly extending north of Crocus Lane and the spatial impact, the impact of that spatial extension.
All right.
I can talk you through individual photos if that helps, but they're just there as an illustration.
I think the inspector can flick through those. We've got just 5 photographs in there, haven't we? So you've drawn attention to what you've wanted to in that. I'm conscious of the time. I'd like to move on to the next topic, Inspector, which is that of flooding. I want to just to run through this in this way. So after the evidence that we've had on flooding, we've got an issue of sequential test, which has got some elements that you address in your proof of evidence, and we've got an issue of the community benefits first part of the exception test, which again, both you and Mr. Woods address as a planning matter. In terms of the sequential test, following the questions put by myself and the inspector, we're agreed that it has to be done. In respect of site A, it's failed, and we've had the amendments to Mr. Woods' proof of evidence in relation to that. In relation to site B, we've got allocated sites as the starting point, and we heard evidence on those. And you'll recall that I and Mr. Woods discussed these, and we know that 2 of those allocated sites, DS 18 and 20, have been permitted for others that Mr. Woods is dealing with. So those ones I don't want to detain you with. And you'll recall that I already discussed NPPF 180 with Mr. Woods last time round and the consequences of that. I don't want to take up time on that either. What I want to ask you about is really where that leaves us in terms of allocated sites in respect of your evidence. And in particular, the sites of DS 15, DS 17 and DS 19. Now you have provided for us at CW 14 of your CD 10A.5. So Inspector, it's CW 14 that you want to be looking at, and it's within 10A.5. So we can see there in your appendix CW14, which is an appendix to your rebuttal proof of evidence at CD 10A.5. And I can see the inspector has got a copy of that, a hard copy of that. And so can you just help us there? We can see on that you've got Lydia Park marked, haven't you, in yellow down at the bottom
Yes.
right-hand corner. And then you've got those 3 sites that I've referred to, DS 15, DS 17, and DS 19. So are those the ones we can see where you've marked them in red with a little arrow pointing to them? DS 15, 17 and 19. So one of them is just, well,
DS 15 is located a short distance west. 17 and 19 are more distant.
and can you remind us of,
I think 15 kilometres was referred to, but they're more distant from the site.
and in terms of the numbers that we are allocated for on those particular sites, can you just remind the inspector of what the numbers are in respect of 15, 17 and 19, please?
Yes, it's helpful if these are obviously from the local plan part 2, so I can give you the page references if that helps. But DS 15 is addressed at page 166 in chapter 7. These are obviously the allocations, and DS 15 is referred to as Stovolds Hill, and there's an allocation for 3 gypsy and traveller sites.
Pitches.
Sorry, pitches. 17 is a site known as Monkton Farm.
Sorry, what farm?
Monkton.
Monkton Farm, yeah.
And that is allocated for a total of 6, but net 5 gypsy and traveller pitches. And 19 for a total of 3, but net 2 gypsy and traveller pitches.
So you'll recall that Mr. Smythe gave evidence on the appropriate search area size, and he gave evidence on the size that DM 37 requires and all of that. But what I want to ask you is, in respect of two of those sites, DS 15 and DS 17, so that's Monkton Farm and the Burnt Hill site, being for 3 and 5, insofar as it were relevant as to whether or not one should split up the existing families on B when considering the sequential test, what's the consequence of the allocation being for 3 and 5 in those particular allocated sites?
Well, the consequences are they're allocated sites, so there's no actual need to do the sequential test. So effectively, they are sequentially preferable sites and sites which are available. And I didn't read out as I went through them. I can go back if need be, but all meet the search criteria of in excess of, or Mr. Woods' search criteria of in excess of 0.3 of a hectare.
All right. And in terms of then just for completeness, you also deal with Mr. Woods' sites, which he did in his manual search of estate agents, his sites 1, 2 and 3. Within your rebuttal at 2.14 and 2.15, you look at the Inspector Hand decision and the consequences that that has in respect of the way in which you apply the sequential test to sites, and you give you quote from Inspector Hand at paragraph 11, as does Mr. Smythe. I just want to ask you in respect of the inspector's got what Mr. Smythe has said in respect of site 2. And Inspector, you remember that site 2 on Mr. Woods' search was the one that he discounted on the basis it was over the boundary with the nearest local authority area. So I just want you to help the inspector with what you say within your evidence as to the logic or otherwise of excluding site 2 only on that basis. So you address that in your rebuttal evidence at 2.15, but can you just explain for the inspector broadly what your view is on saying, well, site 2 may be sequentially preferable, but it's over a border. I think you say it's 6 kilometres away, the existing sites are 6 kilometres from the border. So what's your view on that?
Paraphrasing quickly, what's in paragraph 215, my thought is, or my conclusion is, that when you're looking for a site to meet the needs of a particular applicant, then potentially obviously there are certain criteria in terms of what that applicant is looking for. And in the current case, given the fact that we have a number of gypsy and traveller families who are looking for a site based on the evidence submitted, particularly yesterday, with ties or proximate to Lydia Park, then a logical area of search centred on is probably too strong a phrase, but will certainly take into consideration the proximity of sites to Lydia Park. So to the extent that Mr. Woods was happy to look, I think sensibly to look at sites within the borough of Waverley, it also seems sensible to look at sites which are equally proximate or similarly proximate to Lydia Park in other areas. And that would take you over the borough boundary into adjoining land.
And then finally on this topic, can you just help the inspector again with the principle as you discuss it in your evidence? I've referred the inspector already to where you do that at 2.14, but the principle of excluding sites 1 and 3 on the basis of non-flood related matters in relation to the Culmer site and site 1. What's the principle the inspector should be applying if he needed to look at sites 1 and 3, given the evidence you've already said? What's the principle
Well,
he should be looking at for the sequential test?
The principle established by Inspector Hand there is that when you're doing the sequential test, you're focusing on the flooding issues, and that's what he says should be considered first.
And so if the consequence of that, yeah, go on.
Flooding is the consideration in your sequential test, and other matters may be relevant at a later stage.
And just pausing there, Mr. Woods talks about an authority called Angela Smith, looking at whether sites are available alternative sites for people to move to. And he conflates that with the sequential test and suggests in his evidence that unless you have a site which is, in Angela Smith speak, available, affordable, suitable, and on all the particular criteria relevant to that particular applicant, then that's not a suitable site sequentially in flooding terms. Now, I want you to specifically help the inspector with whether you say that is the correct approach, or whether you say that those considerations apply in the separate consideration of whether there's an alternative site and the weight to be given to that later in the planning balance.
Well, suitably paraphrased, but basically, no, the Angela Smith judgments, those criteria is something which you apply at a later stage, potentially when considering need and the availability of other sites. It's not a test which is applied as a sequential test when you are just simply addressing issues of flooding and whether a site is suitable or not from a flooding point of view.
So, Inspector, I want to move on then to the exception test, and the part of that relates to community benefit. And I wanted to do this, Inspector, by having a look, just reminding ourselves of where within the PPG one sees this addressed in terms of community benefits. So could I ask us all, wherever we've got it, to have a look at the PPG on flooding again, but this time we've looked at some of the paragraphs, Inspector, particularly 27 and 28, but can we look at paragraph 36, please?
Sorry, I wasn't paying attention then.
It's all right. No, it's unfortunately that sometimes happens when I'm rabbiting on. So paragraph 36 of the PPG on flooding.
So I'm looking
So
at
my internet is a little bit slow, but today,
well,
but
I've just got the
printed out.
document. I'm just looking.
So paragraph 36, I can read it through if that's quicker. I'm just looking for really your view on a point of principle.
Well, if you read it through, if not, I can. If you give me the chapter or heading, I can go quicker. But if you can read it through,
I'll read it through. So it's Inspector. It's that paragraph that starts. How can it be demonstrated that wider sustainability benefits to the community outweigh flood risk? And Inspector, you'll see there's a first paragraph there. Local planning authorities need to set their own criteria, etc. And it's really the second paragraph that I want to ask the witness about, Inspector. Examples of wider sustainability benefits to the community could include, first bullet point, the reuse of suitable brownfield land as part of a local regeneration scheme. The second bullet point, an overall reduction in flood risk to the wider community through the provision of or financial contribution to flood risk management infrastructure. The third bullet point, the provision of multifunctional sustainable drainage systems that integrate with green infrastructure, significantly exceeding national planning policy framework policy requirements for sustainable systems. And then it goes on to remind us that when applying the test, those benefits need to be balanced against the flood risk as the second part of the community benefits test. So what I want to ask you is, those are examples of wider sustainability benefits. So you and Mr. Woods obviously don't treat them as conclusive, but can you help the inspector with a point of principle that one can derive from that as to the nature of benefit one's looking for when the when the framework tells us to take a look at wider sustainability benefits, please?
Well, from that paragraph, the examples, I suppose, of sustainability. Two of the three focus on flooding, particularly on flooding benefits, one on the first one on brownfield sites. I've drawn in my evidence at 227, 228, I think, a wider distinction than that, but they certainly need to be wider community benefits. So it's been usually benefits beyond the site itself, or that's going to meet the needs or provide a benefit to the wider population. And so the examples there in terms of a reduction on flood risk, I think said beyond the site boundaries, etc. So particularly if the example there, and I say it is only example rather than binding, is if the flood risks you were mitigating or providing on a site actually not only solve the problem on the site itself, but potentially to a wider area. Now, I don't think you need to only consider flooding benefits, but certainly there has to be a wider community benefit that goes beyond the development on site itself.
And then
And that
what
could be misleading because potentially if in a scheme for infrastructure on site, then there could be benefits simply by the development itself on site, for instance, if it is a transport interchange or something, but it's not just a benefit to the application sites.
And in terms of the second element then, what's the significance before we get to that element of the community of the exception test being passed? What's the significance of the need to weigh to balance those any benefits against the associated flood risks?
Well, whatever benefit you are actually considering needs to actually outweigh the flood risks identified with the site, which in this case, going beyond the question, we know to be high.
All right. And so I suppose the last question that I would have for you on this, well, not on this topic really, but on flooding is conditions. And you'll recall that we touched on this with Mr. Woods, and we looked at the Loddington case in Appendix 7 of Mr. Sibbitt's evidence. And I just want you to help me with what your take on what Mr. Woods says about the ability of the issue to be conditioned in some way. What's your take on conditions if it's suggested that there's not a problem because everything could be conditioned?
Well, the importance of a planning condition, if you're addressing flood risk, is you must have sufficient information to show that whatever system or package you are inviting via that condition and is being put forward is likely to be viable and is likely to be operable so as to address the flood risk. In this case, the discussion on conditions comes next week, but on the information that's generally being talked about, we have very little information about what that system might address, and I've heard nothing to suggest or gives me confidence that a drainage condition could require a scheme which wouldn't adequately address the flood risks on a site that's at high risk. I can say more on conditions, but the further comments on conditions probably come to when we discuss that condition next.
Well, it's a matter of approach really that I'm looking at, and in terms of what you've identified specifically, what do you say about the evidence before the inspector, which has to be in the flood risk assessments? What do you say about how successful they are at identifying the problem, the first step you talked about? Do they identify the extent and nature of the problem that needs to be addressed or not?
Well, no, the two flood risk assessments, which are submitted now quite a long time ago, but with the original applications, neither of them give any recognition of the drainage or drainage works in terms of drainage facilities that have been removed from the land. So neither of them actually address the actual drainage regime that exists across the sites and adjoining land at all. So in terms of the flood risk assessments, they just don't address it. And in terms
And
of,
pausing there for a moment, in terms of the latest mapping with the latest rainfall patterns in the EA flood mapping, do either of them address that in terms of if that's relevant to the nature of the risk?
no, they don't.
And then in terms of the second element you talked about, the need for there to be a solution provided that the inspector can have confidence is going to address any problem. Well, you already addressed whether or not we've got an identification of the problem. In those circumstances, could it be sensibly suggested in your view that one has got a evidence on whether a solution is possible?
Well, again, paraphrasing it and without meaning to skip too lightly through what's being put forward, but the main proposal that seems to be being suggested at the moment is a reinstatement of the water course across the various sites. My understanding of Mr. Smythe's evidence is that high risk of flooding exists based on mapping with that water course in place, which is why it shows a high risk of flooding basically spreading out from that water course. So simply putting back the water course that was there previously to whatever extent it was in that data still leads or still identifies the high risk of flooding. So you would need a drainage scheme which improved upon the pre-existing situation.
Are there any details in the flood risk assessments at all as to what that might be or how it might go about that?
No.
And in terms of the reliability of those flood risk assessments, given answers to questions the day before yesterday, in terms of how the flood risk assessments had identified the sites, in particular, what structures they'd discussed being on the site A and how they'd addressed that, what do you say that means in terms of the ability to have confidence in those assessments as to them properly assessing the actual situation on those sites?
Well, neither assessment gives any details of what drainage existed on the site that somebody was there, although both refer, and paraphrasing briefly, or that, unless I need to go into the assessments, to the retention and keeping clear of existing water courses, etc. And indeed at that time to the applicants having a clear understanding of the need to do that.
But what that wasn't the question. The question was in terms of
Moment.
So-
I don't defend under report signing up to PLB as the way forward. We would achieve the improvement on the development conditions through the surface model that would have to be carried out.
where do you see that in any of the evidence, Stephen? It's not in the evidence, is it? It's not in the evidence anywhere before the inspector. Well, you can make your submissions on that, but it's not in the evidence.
Okay. So
Thank
can
you.
I just say that what's in the evidence, just so we understand, is a condition that proposes modelling and action to be taken on it. The modelling isn't in the evidence because it hasn't been done. So that's plainly obvious.
So, well, you can say what you want in your closing submissions. I'm examining my witness, Inspector, at the moment.
Yeah, well, the reason, Mr. Linton, I'm objecting is because I don't want you to use a remark made by a friend as an excuse to make a speech.
No, well, I mean, I accept that, and we shouldn't comment on the evidence. But the point I put to you, and I'll put it to you again very specifically, is this: given that the underreport upon which my learned friend relies for Appeal B misidentifies the site itself within that document, and given that the Flume report for Appeal A talks about buildings being on a site where we know there aren't any buildings, What do you say that means for the confidence the inspector can have that those reports are properly capable of being relied upon in any way as demonstrating that if a condition is suggested, that is going to be achievable? That's the question.
The confidence, I have severe reservations. I put it, I think, in my original evidence about the accuracy or the detail that went into both of those reports, and the level of, if anyone had done a site visit, if they'd done a site visit, the level of scrutiny they'd done, seen at that site visit in terms of not actually recording the drainage features or lack of drainage features.
I'm very grateful. All right, so just the next topic, Inspector, is that of sustainability. Not a big topic, and I'm not sure before cross-examining Mr. Woods how much there is between us, but Mr. Woods accepts fairly, with respect to him, that most journeys will involve the use of a private car. Sustainability isn't a reason for refusal in this case in terms of transport and locational suitability. But if it was suggested in some way that sustainability in this case was a positive, if we get to doing a sort of planning balance, leaving aside all of the other considerations we talked about, what would you say about whether or not it should be a positive factor in favour of the appeal site sustainability, or whether it's neutral? That's the only question, really.
I've got to identify it's not an issue for a reason for refusal, and that is against, I think, the background that the council has accepted, that there is a large amount of gypsy development at Lydia Park, and by the fact that the council has been content to grant permission for those various sites at Lydia Park, then clearly the council is not concerned that the sites are wholly unsustainable. But Mr. Woods correctly addresses in his proof that most journeys will need to use a private car, and reference, I think we differ slightly on the differences, but most of the services are available within the local village of Dunsfold and Cranley. They are each only accessible by car. So I agree with Mr. Woods on that sense. However, the fact that those journeys are not long isn't a particular attribute or a positive factor for the site. And crudely, it's no greater factor than any of the other sites on Lydia Park. So it's not something the council would object to, but equally I would not agree that either any of the sites are highly sustainable to be a positive factor.
All right. So the next issue then, I think we've had, Inspector, a lot of ecology evidence this week. Mr. Woods has given his evidence on that. I'm not going to ask any evidence about ecology per se, but there is one question that I want to ask about ecology that I'd like to have your view on from a planning perspective, please. And that is this issue that's been suggested that, well, because the appellants personally may not have been responsible for cutting down any and all trees and filling in the watercourse, essentially, because they personally may not have done that. The baseline that you have to apply when looking at ecological harm in respect to this development is with those works, i.e. the tree removal and the works in relation to the watercourses, already done. So I want you to address and just help the inspector with that comment, and I want you to give him clearly what you say the position is in terms of the correct approach in planning to the any fallback position and the baseline.
Well, when establishing the baseline, I think who undertakes the development is largely irrelevant, because the inspector in that context isn't looking to see who undertook certain works or what works have been undertaken, but he's looking to deal with the applications before him, and that involves dealing with the applications as they're submitted, having regard to the description of development, And I think I'm correct in saying that in each case, those descriptions, I'm sure I'm correct in saying that in each case, those descriptions include the laying of the hard standing. So that is one of the factors that's included within the application. I think each of them is retrospective. So the applications, to the extent that any hard standings did exist at that time, includes those hard standings which did exist on site. And I pick out that none of the application details we looked at actually refer to a previous state of play or suggest, I use a broad phrase, but that the site is already a brownfield site that's already been developed. So that is absent from any, and I don't believe it was a case, but that's absent from any details submitted with the application details.
So in terms of,
And
you go on, sorry.
Sorry, the final point to make really on there, well, I say final point, there's a couple of further points. The fundamental use of the site as a gypsy site relies on those hard standings and any further works that have been carried out since to be used as a gypsy site. So you can't disaggregate those hard standings from the land use. And in terms of the details we've been provided with, I've not yet seen a clear separation between the two activities, that a hard standing was laid and then at a later date an application came along to use that hard standing and use it for gypsies and travellers. In my mind, it's all one operation.
Now, the council has served enforcement notices in respect of appeal sites C and D, and in respect of A and B, said it's waiting to see what happens on this appeal, which has been going on for a long time. But what's the relevance in respect of Mr. Wood's answer to the inspector's questions that he accepts that enforcement action can be taken? What's the relevance of the fact that enforcement action can be taken to remove the hard standing to the baseline when one looks at the harm that's been done? The fact that it can be removed, what's the relevance of that?
Well, the effect that enforcement can be taken to remove it means that Mr. Sibbett is perfectly correct in looking at the baseline should be to the extent that the sites will revert back to what was there prior to those hard standings being laid. Mr. Sibbett was obviously asked on how quickly land would restore, but that's a separate issue, I think, to what the actual baseline is.
All right. So, Inspector, just quickly then, intentional and authorised development. The Inspector is familiar with the principle, and we've got authorities in there, such as Loddington, which the Inspector has already been referred to. For your note, Inspector, Loddington's at Appendix 7 to Mr. Sibbett's proof of evidence, actually, because I think he was involved in that one. And I don't think the principle, well, I know Mr. Woods doesn't dispute the principle of intentional and authorised development, but the question will be, how is that principle applied to this site? And similarly to my last question, really, I just want to ask you that if it's suggested, and it's not in evidence, but I'm just asking you in terms of the principle, if it's suggested that, well, the appellants themselves may not have done all of the actions which are intentional and authorised development, how do you say that the principle applies, given that we're dealing with a use of land here? What's the inspector judging when he's looking at intentional and authorised development, when he's deciding how much harm to award for that? Can you help him with that, please?
Well, the main principle is the inspector needs to consider whether that development was lawful or not, whether it is carried out for any legitimate purpose. And I think in this case, the conclusion can only be that there was no justification for the laying of hard standing. There was no justification for the filling in or bridging or filling in of water courses. We heard evidence from each of the appellants yesterday into the extent to how each of those first perceived the sites and their evidence in terms of what was on the site when they first took it up. But in terms of the principle of that, you need to look to what works were done, whether or not they were lawful or whether they were unlawful, and what the consequences of those works were in terms of the acceptability of the development. And clearly potentially the most extensive or the most significant of those relates to flooding, but you also have the impact of that development then on ecology and landscape issues as well. So the inspector has to consider the implications of that development set against the harm that's actually being done by it.
And I know the inspector's been taken through the evidence in terms of flooding, ecology, landscape, and he's got a good note of what's been said in the evidence yesterday. So I'm not going to take you, just with my eye on the time, I'm not going to take you through individually each site and what's said in respect of each site, but the inspector's got the principle there to apply. And in terms of your view, given the evidence that the inspector's heard in respect of what's happened in terms of flooding, and given what he's heard in terms of what's happened in terms of ecology and in terms of landscape, where on the scale do you say, as a matter of judgment, this development comes on the scale of weight to be given to intentional unauthorised development?
I would give intentional and intentional unauthorised development considerable weight, because in each case, obviously there's differences between the sites in terms of, not least of which is the different sizes of different sites and the different extent of hard standing. So potentially there is more, potentially in reality, there's more development on site B than there is individually on site C, D or A. I wouldn't want to just rank those in terms of the extent as a straight table. But in terms of each of the sites has had a very significant impact in terms of laying of hard standings, effect on the watercourse, drainage, ecology and landscaping.
All right. And Inspector, that takes us on to the final issue before the planning balance, which is the best interests of the children. In respect of this issue, it's really what the principle is that the inspector should be applying in terms of what are the best interests of the children in this case, and then the principle applied in cases that you refer to, such as that of Stevens in your Appendix 12, and it mostly a matter, I suppose, for submission. But in terms of looking at the first of those issues, best interests of the child, what do you say, given where we are in the evidence, as to what the best interests of the children are in this case?
Well, it's recognising on the base, and particularly yesterday we had an update in terms of Site D with a family now living on site, whereas previously only one male member living on that site. That's Matthew. Yes, thank you. I apologise. I couldn't remember Matthew's name from yesterday. So, but previously, and I identified that in previous proof.
Sorry, I was going to say that.
You did the same thing, yeah.
Like the Gospels, Matthew and Mark. Sorry.
No, I could remember the various ones. I was trying to distinguish between Mark and Matthew, but in terms of who, sorry, in my proof, I dealt with the impact and the families and who was on site.
Oh,
Yesterday we had an update in terms of Matthew, because in my original evidence he was the only potential occupant of the site. We've now learned that he's been joined by his wife and various children, etc. So the circumstances on that site have changed from my original proof, and I'll deal with that when I move on to weight in a minute, because I need to update that. But in terms of the best interests of the children, for the children collectively across all 4 sites rather than dealing individually, then clearly there are a number of children on the site, and therefore it's recognised quite simply that they have the benefits of a settled base. They have the benefits, I think, in terms of all families, of children at school or potentially at nursery or potentially going to school soon. We have several children with special needs that are being met, etc. So the interests of those children is clearly a considerable weight to be given to them being able to continue with healthcare and with education and to having a secure base so that that can happen. My concern that's moved on from my original proof is now that given the escalation of flood risk as we've progressed through these inquiries, that flood risk potentially puts children and there's children with healthcare, but anyone else with health needs, anyone else with needs to have a safe place in which to live, electricity, etc., at risk. So
I appreciate that.
I think
Yeah,
the
go on.
best interests of children are significantly diminished on this site by the fact of flood risk.
Well, that wasn't what I asked you, because what I want you to address your mind to is if the inspector is asked to grant personal permission, because that's where individual best interest would come into account. Can you be clear as to whether, given the flooding considerations, in your evidence, in your view, given what you've heard, the best interests are on the site or being off the site? And obviously that's something the inspector is going to need to address. We've had the case of the Inspector Dignan case, which has been referred to, where he said the interests were best served off the site. Other cases where inspectors have said different. So what's your view, given what you've heard, particularly yesterday?
I think the best interest of the children on site would be served. Contradiction, my phraseology there. The best interests of the children who are resident currently would be best served off-site.
And of course, in coming to that conclusion, the inspector must have a look at all the evidence, I suppose you would say, that he's received.
Well, absolutely, and that depends partly then on how the inspector decides to move forward with flooding issue and whether that is a substantive and significant reason for refusal or whether it is something he thinks could be adequately addressed.
All right, so you set out the planning balance in your evidence, and I don't really want to I've just come up to 11 o'clock, so that our time is just about there. I don't want to deal with you just reading that out where it's there, because that wouldn't be a useful use of time. I've noticed that one thing though that I would like to ask your help with on the planning balance is that in respect of many of these issues, you say that you've got to allot them a great weight. So in respect of national landscape harm and value landscape harm and views and things in terms of things such as the high risk of flooding. But when we look at 10.1, you've got a table where you tell us how you've given the various categories of weight from substantial all the way down to limited or none. And you don't have great there. So I just want to know where is great in respect of your weight? What should the inspector equate that to?
Great is an omission from there, and given the fact I have attached great weight to several of the factors that follow, that is clearly an
Sorry,
omission.
Mr. Ward, just remind me where you set out that
Sorry,
scale.
that's at 10.1.
Yeah, I knew I'd seen it.
Yeah, because he says great weight, and it doesn't. He's given a table saying all the categories, a bit like a green table. Do you remember where he goes through a million different categories of weight? Yeah, well, that's my reason for the question. Yeah.
So I'm in 10.1, and you're asked where great goes.
Great goes at the front of the list. So great I've heard it is above substantial. Which I think is logical, because given the MPPF simply refers us in various locations to attaching great weight, It would be odd if the MPPF suggested adding.
That is a misreading of the policy, because as with Greenbelt, there's a mandatory requirement to attach substantial weight. If you've got very limited harm in a national landscape, the decision maker is not mandated to attach great weight, but they have to give great weight to the importance of the purposes of the designation. It doesn't mandate you to attach great weight, even if there's trivial harm.
So, and that is why, Inspector, although that again is a submission in the evidence that witness is being given, that is why I'm asking him to be clear as to what he means by great weight, so that you can apply that when you look at his evidence. And he's said very clearly that in terms of weight, where he said great weight, that means weight above substantial. And you'll see where he's allocated that within the various categories. And you've already explained in your evidence previously how the footnote 7 policies bite in terms of flooding, in terms of national landscape, the need for a strong reason. I'm not going to ask you about any of that. You say how structurally you deal with things within the evidence. In terms of the planning balance, is there anything that you feel as a result of the evidence that you've heard that you may need to change, or are you happy with the way in which you've allocated weight within your planning balance?
Can I just want to refer to a note on that, because I mentioned the need to update potentially the evidence in relation to Matthew. So can I just see what I've said about site D?
Well, before we come on to that, as I understand from what Mr. Master was saying, Matthew isn't on the site lawfully. I mean, is that irrelevant? I mean, he's in breach of the injunction.
I'm sorry, I missed.
I think Matthew's in breach of the injunction. So is that a relevant factor to consider or not? I'm just asking you.
I haven't given consideration to whether Matthew's family were in breach of the injunction. So
Well, it's just what Mr. Master said.
the issue was clearly from Mark yesterday. There's a potential issue of him. They honestly saying his brother has now moved on to the site, and I believe that's probably in breach of the injunction.
Well, that's what I was going to say.
Have I got them round the wrong way?
Matthew isn't in breach of the injunction.
It's
because
Mark, is it? Yeah.
No, neither of them are, because of course, that somebody else is. But they aren't, because of course that was what was determined in the decision at the end of the day, and in fact she didn't impose any. She discharged it. So, but of course, did she discharge it completely?
I thought she upheld it, but exempted certain named people. But I've not been involved in the injunction. But
She's not. They're not in breach. But I think Matthew's brother coming recently, if the original injunction stands, would be a breach.
So that's who I was talking about, really, Matthew's brother, which I thought you were talking about as the need to update, but perhaps not.
no, I was ignoring Matthew's brother for the sake of the inspector's understanding, because that's not your
my
application.
understanding is that Mr. Ward wants to update in respect of site D and
Site
Matthew, because there was I think in his original evidence, he understood that it was just Matthew on site, but now the family's together again.
Oh, I see. Yeah, no, I'm
Because
sorry, I
previously,
misheard.
think his
Yeah,
partner was living elsewhere with the children.
yes, yeah. So that I'm sorry, but I'm confused.
I think
matters
that's the
there.
position.
Yeah, I'm grateful.
So the update is effectively there in terms of the family circumstances and the benefit of a settled base, etc. To which I originally gave Matthew less weight than Mark. Then I would now equate the weight between those two sites.
I'm sorry, Inspector, my hearing was going there. I do appreciate that difference. I'm grateful for your intervention. And so unless there's anything else that you want to say in respect of that, Mr. Ward, I think that's all the questions that I have for you.
Mr. Ward. Mr. Ward.
Mr. Ward, you might need to shuffle round
Oh.
for Mr. Masters to ask some questions.
So would you go that way?
I'll go that. I was going to ask for one.
Can I just check to maybe
Please, because there may be.
On page, I think they're both in your original proof. First is page 62.
Yes.
I don't think in the first line it's CW1, the appendix that's being referred to, because I don't think that's a series of photographs. But I couldn't work out, you have several aerial views. So I wasn't sure which one you were directing the reader to. I think I've written a note to myself, is it appendix 5?
I think if that's the one you were referred to yesterday, which is the coloured one with all the arrows and the sights on. Let me turn it up and just be sure.
I want you to be sure about what you're saying.
Yes, it's that one.
Which is,
It is appendix 5.
It
the
is
original
5.
Appendix 5, yeah.
yeah, thought it probably was. And the other one, yeah, page 79 and 12.25. Either
Yes.
it's a question of the type of flooding that you refer to on the second line. But I don't think the evidence does relate to fluvial flooding. Which is what
No, it isn't. It isn't. I think that's surface water
yeah,
flooding.
or pluvial, yeah. Yeah. Okay, thanks for clarifying those 2 points. We'll take a break. It's virtually 11:10, so adjourn and back at 20 past, please.
It is in the supplementary evidence, which is in 10C.
10C.
With one.
Thank you.
I think it's appendix 20.
Yeah, trying to see appendix doesn't help me because you can't trace it by that. When you say it's in the supplementary evidence, is that a, is,
It's 11:20 and time to resume.
sorry, I should perhaps say, it's still morning, I think.
No, no, no concern at all. Okay, Mr. Masters, when you're ready, please.
Good morning, Mr. Ward. I had to decide myself whether it was morning or afternoon, but it's definitely still morning. Look, there's a lot to get through. And I wonder if you could help me a little bit. If I ask you a question, okay, I will allow you the opportunity to make your supplementary remarks, but if you could then just address the question first, that will save us all a lot of time of me repeating it. Secondly, I am not, sir, going to be going over every issue that you've raised in your evidence, because a lot of things have already been covered elsewhere. For instance, you know, you dealt today with the sequential test and flooding. A lot of that's already been dealt with. I know the sequential test element to planning is slightly separate, so I'll ask you a couple of questions on that, but I'm not going to spend a long time on that because I don't think the inspector would appreciate us going, he's already got the issues. Okay, and I don't think I need to repeat the issues with you because he's already understands them and we understand where we disagree. Okay, so help us to try and move things on quickly. Okay, if you can, Mr. Ward, and we've met before, Mr. Ward, haven't we? So we both know each other, right? So the first part of your evidence is your introduction, and then you spend a lot of time describing the site, and I've got to say your descriptions of the sites are a detail and a joy to listen to, better than a lot of other people as a go. So I'm not going to cover those areas, okay, because there's no point. So I'm going to go to page 15 of the original proof. That's the one I'm looking at, okay. I know that there's been things, but you know, I'm going to base it on the way your main evidence is to be found. I know things have moved on, and we'll deal with that. Okay. Well, that's what I thought from both of us. Okay. So if we get there, we've got the details of the 4 planning applications. Okay. Now let me just pause there. Although it's not part of this case, there's been enforcement notices served relatively recently on Appeal C and D, haven't there? If you don't know and you can't get the details.
Mr. Ward, you need your mic on. I'm really struggling to hear that.
Sorry, I've moved around the table.
Okay. Can you remind me the dates those enforcement notices were served? I know that they've been appealed.
Off the top of my head, no. I may have them available to look up, but I can't off the top of my head.
Okay, don't worry.
CW 20 for the inspector's note, if he needs that. So
I'm happy to go there if that helps.
Could you, if you could get it up pretty quickly, that just might help the inspector to know what issues that covers.
So Inspector, I can see you ferreting away through your printed stuff. It's in the supplemental, first set of supplemental, but not all.
I'll just wait to get.
Yeah, okay.
I just think it'd be useful so to have that information, so
No, I have them, if I hesitate, it's because I have them marked in the terms used for enforcement, which is plots 1, 2, 3 and 4, not C and D. But I'm pretty sure I can work out which is which.
but I thought it was only C and D. Is the enforcement notice served on all 4 plots?
It's different form, isn't it? 3 and 4, C and D.
Yeah.
1 and 2 are the ones south.
Yes, yes, that's what, thank you, sir.
So your question is what the date of the notice
But
is?
the date of the notice and what is covered, is it use and operational development?
For plot 3, which is D, the breach is described as a material change of use to a caravan site. Sorry, I'm paraphrasing.
Yes.
Associated development facilitating that use, erection of fencing, erection of outbuildings, installation of lighting, installation of surfaces.
And the
And then-
date?
Sorry, can we carry on? And
Yeah.
secondly, an engineering operation comprising the laying of hard standing within the area outlined in red. The date is the 30th of May, to take effect is the 30th of May 25, data service 22nd of April.
And those have been appealed, have they? But there's been no,
They've been appealed.
but there's been no determination of those.
No, the same inspector who is dealing with the appeals for pitches 1 and 2 is determining the 4 currently is it determining the 4 enforcement notices as a written rep submission following or coincident or following that inquiry.
Okay, and that's D, and then there's C.
That was DC, just write C. I think it's the same, but the material change of use to residential caravan site, associated development, fencing, outbuildings, lighting, services, and an engineering operation comprising the laying of hard
Yeah, exactly the same
Yeah.
date,
standing.
30th of May,
22nd of April and 30th of May to take effect.
Okay. Thank you, that clarifies that. Okay. And if I can just pause, we know that, and I'm paraphrasing because I'm not going to take you to it unless we need to, although I know I will be taking you to it a little bit further along. The reasons for refusal here, put simply, are 1, effect on character, 2, dominance, C, failure to supply information relating to protected species, and lastly, failure to provide information relating to flooding. Okay. To a large extent, flooding protected species have already been over those grounds in detail with specialist witnesses. So I'm not going to ask you anything, because I don't think it would benefit anyone to do that. And again, with the landscaping issue, I know you've covered that a little bit, but we've covered that extensively in the landscaping evidence already.
I'm sorry, I'm nodding, but I
know, no.
I'm happy with that. Well,
Okay,
I
so
understand that.
So let me then move on to the way that I'm looking at it. So I've moved over the landscaping character stuff that is on your pages 22 and 23, and issues of whether or not you regard this as valued landscape, because that's all was all covered at great extent with Mr. Dudley and with other people. Okay. So we then come to, I'm going to take you to AHN4 at para 29.
I'm sorry, page 29.
29. So this is, I said, so I'm always doing this. I said para, but I meant page. Mr. Ward understood I meant page, thankfully. But I don't think you did, sir. And it's para 521. It's been a long week, you know. I've got to say, for everyone. So sometimes, when I work on the basis of I can drive home and back, it's more tiring than sort of when people stay as that. So give me by the end of a week, it takes its toll occasionally. So here we are. We've got the let me just see if I can do the first part of ANH1 is sort of allocations and need and supply rather on how you're going to achieve whatever there is. Okay. Now, can we just agree this? I don't want to spend a lot of time on this because we're coming back to need and supply as its own session for the second time, because we did need and supply as its own session before you brought the new policy in, which we had to do it again. Okay.
We now have new
But-
information, yes.
I'm not criticizing, I'm just
No, no.
trying to paraphrase. But can we just agree this, right? Your case was, okay, originally based on a different calculation of need, but policy HN4 identified a certain element of supply that would cater for that need. That was your original case.
Yes, well, the issue of need was largely addressed by Mr. Jarman rather than myself.
I
But yes,
know.
yes, it was a
But
different. set
you
of
dealt with
data.
it as well,
Yes, no,
unfortunately.
no.
Okay, right, that was your original case. Sorry, I got distracted by somebody with a megaphone. Anyway, things have moved on because you had the new GTA, massive numbers, and with that GTA was this, forgot what it's called, but the document that identifies potential sites to meet that need.
PDA.
The PDA,
planning
thank you. Yeah, okay.
Pitch delivery assessment.
So now your case is, now you would have to accept, wouldn't you, that and there are two parts to the local plan. There's a part dated 2018 and there's a part dated 2023. In relation to the local plan, as it was, it doesn't address the current need. And that's what you're seeking to address in the PDA.
Certainly, the current adopted plan doesn't directly address need that's arisen at a later date or been identified
Yeah.
at a later date.
Now, there are lots of reasons for that, okay? The original GTA was based on the 2015 definition. We know that that definition has been criticised in the Court of Appeal. As a result of that, the PPTS has changed the definition. We know from the case law in Smith that the calculation based on the 2015 definition was about 2/3 less than it should have been, because that's the way the Equalities Commission put it. Anyway, the numbers now are much greater, aren't they?
Probably, although again, the numbers and the GTA and those details are issues addressed by Mr. Jarman. So although I have read through them and have a very loose understanding, that's not my expertise.
I understand, and I'm not holding you to that. Okay, but the point is, my submission is that there's a clear failure of policy here, based on using a flawed original policy in a GTA, and the result is that you've not properly met your need. There are no allocations to meet your need, and this local authority is now trying to catch up on and to provide sites that should have, we say, been provided a long time ago. That's my position.
I understand your
Okay,
position.
Mr. Woods. Mr. Ward. So, do you accept that the policy has failed currently to meet current need?
No, and the answer to that is the policy can't address a need arising at a later date and potentially significantly later date, to which it's had no advance data at the time that the policy is adopted. So
Okay.
it's addressing a different situation.
Okay, I understand that. my position is that if a local authority adopt a policy based on the definition that's been declared to be unlawful, okay, and it follows that the adoption of that policy is a failure in itself because it follows an unlawful policy, and the consequences of it rest with you, not with anyone else, and certainly not with the gypsies concerned, because we've been telling you for years that the policy wasn't properly representing the numbers.
Inspector, I
No,
don't want to interrupt
Sorry.
Mr. Masters, but just in terms of what's said, I mean, it's not for this witness the details of need, but of course you will have looked at the documents. We had the need discussion last time. This is a GTA that covered all travellers. It didn't distinguish and say, well, we're not going to cover those not met by the definition. And the previous situation was that all the need was covered to the end of the plan period. So I just want it to be, Mr. Masters, be careful what he puts to this witness in terms of those sorts of aspects, because it is important to look at what the particular local authority is doing and how it dealt with it.
Well, it's all right. What I'm putting to this witness is what my submissions at the end of the day is, so he's got an idea of what I'm saying and he can comment on them one way or another, which is all I'm doing. So I think you understand my position.
I think I understand your
Right.
position.
You don't agree with it, Mr.
I-
Ward?
I
Okay.
don't agree with it.
So
but-
I'm not-
But with
but
the
I'm-
caveat that I'm not the expert in that field.
No,
so.
so to a certain extent, I covered some of that. We'll be coming back to the round table on that. We'll be making submissions at the end of the day on it, okay? So I just wanted to, on that part of AHN4, to set out the differences between us so the inspector understands what they are. There's no point in me asking you any more questions of that because the inspector's got your answer. He knows my position and it'll be a matter for his judgment at the end of the day, okay?
Understood.
Okay, so let's move on to the criteria, that part of the policy then. I've always gone too fast sometimes for my own well-being in questions and stuff like that, which sometimes means that I might interrupt you or trip you up because my brain is working that fast. I don't do that out of impoliteness. Sometimes it's just enthusiasm. If I do, just tell me, Mr. Ward, okay? So I just want to see which ones we aren't in issue. Safe and convenient vehicle and pedestrian access. Of the 4 reasons for refusal, none of them relate to sustainability. So that's not an issue, is it?
It certainly wasn't an issue. It probably still isn't an issue, but in my copy, I put ticks or crosses or question marks against some of these policies. In terms of it was not a reason for refusal. Whether it is now an issue partly depends on the flooding issue, which we've debated and is for others to determine. But whether the safe and convenient pedestrian and vehicular access, flooding will be a factor in that.
Well, I understand flooding is an issue and a factor. So I understand that caveat, okay? But say for that caveat, it's not an issue, is it?
It's not an issue otherwise.
Thank you. And there is an easy and safe access to a strategic road network, and site does not generate traffic of an amount or type inappropriate for the roads in the area. That's not
an issue.
Right. Okay. The site is able to accommodate on-site facilities for parking, manoeuvring, and storage, play and residential amenities. Pause, I should say, of course, I represent, just to remind you, A, C, and D. So that when I'm looking at sites, I'm not asking you questions about sites A, C, and D. Okay. So if I say site, I mean plural
3.
sites, yeah. Okay. But that's not an issue in relation to any of them, is it?
Again, only with that, I don't want to beat the drum too much, only in terms of, is it able to accommodate, depending on flooding could be a factor in that. But it's not a reason.
I think you're
for
stretching
refusal
that,
at the
Mr.
moment.
Ward, I don't,
Well,
B and C, okay? The only issue about flooding with B and C is not it on site because they're completely outside the service water flooding. It's the access, okay? With A, I accept. It's the reverse because the service water flooding red line seems to cover the whole of the site. So I accept with A, that might be true, but not with C and D.
I'm sorry, can I ask a question? You just said the 3 sites you represented. I wrote down ACD. Did I write that correct?
You did.
Right, thank you.
And did I just say something different?
I was going to say, I heard B there and that confused me, but
No, it's me, not
that's,
you.
no, that's fine. That's fine. I just wanted,
Yes,
having
but
laid
no-
that as a base, I wanted to
Well-
proceed knowing what I was, yeah.
no, that's fine. So, Mr. Ward, there can be no issue about B and C.
I don't think that's an issue, but
No,
the
okay.
general background, we don't know where we're going on a couple of things.
And then there is an issue about 5, isn't it? The site does not have an unacceptable impact on the physical and visual character of the area or the amenities of neighbouring land uses. Now,
You skipped one there. I don't know if that was intentional, but
I didn't mean to, so let me just go back. Thank you. 4, the site is located within a reasonable distance of local facilities and services, including schools and health facilities.
you heard
Lo-
my comments on sustainability, but I don't think that's an issue.
No, well, I put it as a not an issue.
Yeah.
Okay, so then we go to the one that is an issue to a certain extent, and I wanted to ask you about the site does not have an unacceptable impact on the physical and visual character of the area. So the term there is not that it doesn't have some impact. The inspector has got to determine whether or not it's an unacceptable impact, which is quite a high test. Do we agree?
Well, an unacceptable impact isn't necessarily that high a test because either an impact is acceptable or unacceptable. The amount of weight you would give to it might depend on how unacceptable it is and how detrimental it is. But it is an issue between us.
Okay. I'll try once more. Okay. The mere fact that there is an impact isn't enough. It's got to be an unacceptable impact. And okay, you and I might disagree what that means, but that'll be a planning judgment of the inspector. And I'm not going to spend ages trying to argue about whether it's a great impact, a significant impact, or whatever.
I thought Mr. Ward had agreed that point. As it was either acceptable or unacceptable.
Yeah, well, I'm grateful, sir. I'll move on then. I may not have understood that. Okay. The second
The
part,
bit bit I queried for clarity was how high that bar was.
that's
Yeah.
that's the nuance I thought I understood. But don't worry, I think the inspector's more nuanced than us because he understands. But what I asked actually was a black and white question. And then it's the second part, or on the amenities of neighbouring land uses. There's no issue about that, is there?
Nope.
Thank you. And then there's no issue. The site is capable of being provided with essential services.
No, I
reason
don't
is
think
that-
there.
not a reason for refusal. No one's ever suggested that you can't have electricity, water and sewage.
My only very slight caveat, and I don't think it's an issue between us, is we don't yet have, with drainage and issues
Conditions.
in the background, we don't know what's happening with sewage, but
Yeah, but like, Mr. Wood,
someone
you've
else may.
granted so many Lydia Park sites without conditions of their sewage. This is exactly going to be the same situation.
I said I
isn't it?
don't think it's an issue
No, good.
with us.
Okay. And then we got the catch-all that's in a lot of policies. It accords with other policies of the plan. Okay.
Yes.
And then you've mentioned some other policies. Well, we can look at other policies at the end of the day. But I mean, that's just a catch-all put there if there was something really important. Generally speaking, apart from character and appearance, then, it complies, doesn't it, with the local plan policy?
Well, the other policies of the plan, just to be clarified, yes, it's a catch-all, but it covers the issues of landscape, ecology, flooding, etc. So we park those issues to the side,
Yep.
but those
We're gonna
are
look
some
at
of the
those-
other policies
yeah.
which are covered.
Yeah, but in relation to 1 to 6, I know they're bullet points, but I've numbered them 1 to 6. It's actually 1 to 7 if you take all of the policies. Okay, we pass everyone but character, which is the issue between us. Now, do we agree? But
Well, I'm happy to take that as a topic,
okay.
but yes,
Thank you.
the other issues are there.
Mr. Ward, that policy doesn't require the appellants to prove need, does it? If we meet those policies, whether there's a need or a personal need, doesn't really matter. It's a windfall policy, isn't it?
Yes.
Thank you. And in the absence of sufficient allocations to meet the need that's been assessed, okay, it is the only referenced, it's the only policy that's going to deliver on the need, isn't it? You say that there is an offsite, and I don't dispute that that's an issue between us, but we're going to talk about that on Tuesday. But in the absence of that, it is the only mechanism by which any need can be achieved.
It's a mechanism by which any applications advocating need will be addressed.
It's the only one. That's the point I'm making. There isn't anything else. There's no allocations whether you're going to do it at present time. Your document within the RS isn't an allocation, is it? We're going to look at this a bit tomorrow, but it isn't an allocation. It's not a policy, is it? It's been through any local plan process.
Which document?
It's PDA, thank you.
No, it's not a policy. No.
Not policy, not an allocation. It's an aspiration, I say, but we'll come back to this tomorrow, okay? So
It
in
won't
the
be tomorrow, but yes. Or I won't be here tomorrow.
I'm starting to panic a bit when he said it for the second time. It's
Mr. Masters, you'll be on your own.
I would be, sir, won't you? Not the first time.
You said it.
I did. Next Tuesday, sorry. Thank you for
Understood.
teasing me. Well deserved. Okay. So at the moment, there is no policy provision for meeting the situation. There won't be for a long time, will you? Because I don't know where we are. I was just going to ask you about now, where we are on emerging plans and timetables for when we might have some proper allocations.
I haven't checked recently. We did provide an update on that at some stage.
But we're
I can
5
go-
years away, aren't we? But particularly bearing in mind, this authority won't exist. So it won't exist next, is it March? April? Is it April Fool's Day it stops?
This authority, I know this authority will not exist, assuming.
Neither will, sorry, it'll be a completely new authority. And I know that the gentlemen who have been elected for those authorities are the ones responsible for working out timetables of these things, and they haven't even got together yet. So we don't have any timetables for what they're doing.
Sorry, I should
Yeah, no,
have,
Karen.
I should have a reference somewhere to the local development scheme. I thought I'd got a copy.
That doesn't really help though, does it? Because that local development is destined for the bin because it won't be followed through. I mean, it's an aspiration that can't even be delivered.
I will need to check to take advice on that one because I just don't know.
Well, see,
I know, and I don't think it's the case at Waverley, but I know a number of authorities are pushing through revised local plans before reorganisation.
I know, but Waverley's not one
I
of those.
don't think Waverley is one.
And
of them.
most of the others are doomed not to make it in time because how can you? I mean, how can you get the inspectorate and everything to start doing a local plan review and everything by next month? It's just impossible. So they're pushing forward to a closed wall, really. But anyway,
it will be a challenge.
yeah. The reality is, Mr. Ward, the picture on when allocations can be achieved is because of a reorganisation really difficult here, isn't it?
Well, again, in terms of the difficulty, depends on what that level of need is, and for
Well,
which I'm going to
we
have
say,
to look to others.
I'm not going to go back over the level of need because we're going to do that on Tuesday,
Yeah.
not tomorrow, but Tuesday. Okay, so if you say, but go over, that'll be my answer. Okay, but the reality is, okay, there is a large level of need that's going to have to be addressed. Okay, And from, at this moment, there is no certain picture as to how long it will take to address. It could be years, couldn't it?
Well, straight answer, and I'm sorry, I'm not picking up on your question. I think it will be years,
Yes.
years being 2 or more probably. If you mean years, many years, maybe not.
I'm meaning 5
Yeah.
at least. Okay?
Okay.
Because we don't even have a timetable for anything starting. And any timetable Waverley had, which they don't, okay, would be superseded by the timetable of the new administration in any event. So that timetable doesn't help.
I simply do not know what arrangements that these authorities are putting in place
No.
for revising local plans.
No. Well, I don't think there are. That's the point I'm making
Well,
to you.
I
And
don't
therefore the
know.
uncertainty is even greater than it would normally be.
I'm sure it is an issue that is being addressed, but I'm not party to those discussions.
They say that about the Labour leadership. We'll wait and see. Anyway, okay, fine. So we'll beg to, we know there is uncertainty. We at present time, you can't help the inspector about any timetable for when that uncertainty might be resolved.
I can't know.
No, okay, thank you. So, you can see why we say that creates an additional failure of policy at the moment. The reorganization hasn't helped the uncertainty of matters. And the one thing that we can't allow is for the failures of local authority administration to actually be a disadvantage for those people in need.
I understand your position on that.
Thank you. Okay. And then we turn over the page, we're on page 30. I'm not going to, just to make the point I made, we got the local plan part 1, which is 2018, which contains, by the way, policy AHN4. I don't know where they come up with these anachronisms. I don't know what AHN4 means, but I much preferred it when it was core policy 1, 2, 3, and 4. At least you understood those things. But anyway, and then we've got the more newer part of the local plan, which went through local plan inquiry in 2023. Both of those parts. The second part doesn't have that many relevant policies. There's a design policy relating to gypsies, DM37, but there's no issues in this case relating to any of that, is there?
No.
No. Okay. So let's move on to a policy I just want to briefly ask you about at page 33, and it's DM11. Okay,
Yes.
and you've made reference to DM11A, retain woodland, important trees, groups, and hedgerows. Okay.
Yes.
Now that wasn't a reason for refusal, was it? Cutting down of any trees not a reason for refusal.
No.
No TPOs at the time of this development. They came afterwards.
I haven't seen the TPO based on what
You
was
got
said,
the-
I think yesterday. I believe it was after, but
Yeah,
I don't know factually.
That's factually the reality, okay? If I'm wrong, someone will correct me later on, but I'm not, because we checked that yesterday, okay? So really, this policy has very little of no relevance, does it? On the facts here.
It's a policy that is now in the plan, wasn't at the time that the applications were, or wasn't, the plan didn't exist at the time.
Yeah.
The plan with the policy didn't exist
No,
at the time
that's
of
the
the
point.
refusal.
One, it
It's
didn't
a policy
exist.
that's come
One,
since.
it didn't exist, and in any event, there was no TPO, there was no, and it was not a reason for refusal, so therefore.
It's not a reason for refusal, but given the fact it is a policy in the current development plan, it is a factor for
But it's really,
consideration by the
its
inspector.
relevance is zero in this case, Mr. Ward, isn't it?
No, I'm not, I don't think it is zero.
Well, the inspector's got our differences, okay? I'm not going to spend ages with a policy that I say came in afterwards of the application. There was no TPO and there are no issues. And that to that extent, a lot of the evidence we've heard about trees and matters of that sort goes in the bin because there was no protected policy, there was no protected TPO. And that's the difference between us. You say, well, it's nice now because I can point to a policy that would have had been relevant had it been in place at the time. But the reality is it wasn't in place at the time.
My understanding is simply the inspector will need to consider the applications in the light of the policies in the development plan. And to the extent that that is now a policy in the development plan, it is a
You
consideration.
know how it works, though. It's got to be relevant to the development that took place and what policies were in there at that time, not what came later.
Yeah, yes, but the relevance is, and I appreciate the reason for refusal referred particularly to protected species, etc. But there was a reason for refusal which put, let's say, ecology on the table as a consideration, etc. So it is an issue which I think is relevant for the inspector to consider.
Well, the inspector's got our point, I think.
Yep.
But we beg to differ in reality to this. And then you didn't. There's policy DM 37 on page 35. I'll just pause for a second. Because there was a little bit of mention of this, but DM 37 is a minimum policy about what's normally an appropriate minimum square meterage for a pitch, isn't it? That's what that goes to, and what should be on the pitch. In fact, it's a very good policy because a lot of policies don't have this sort of design element, you know, that it should be utility building, an amenity area, hard standing, those things. But that's what it's intended to be, sort of its design policy for minimum standards, isn't it? That's the extent of that. It's not a maximum standard.
It's not a maximum standard. So it says at least.
Yeah.
Whether that's a minimum standard,
Yeah.
yes, it potentially is a minimum standard.
And it's not a minimum
Whether
standard.
in reality you
Sorry.
would see a scheme for 450 square metres refused simply because it's 50 metres short, I would hope not.
No.
But yes, it is a guideline for
Yeah.
for what you expect to see.
And the way that I read that, it's a guideline per pitch or plot. So I'm going to keep with pitch because plot will confuse us with travelling showman. Okay, it's a guideline per plot. I mean, if it was 2 pitches, you'd expect a minimum of 500 square meters.
So doing the maths, 2 pitches, you'd expect 1,000 for
Yes,
the 2
1,000.
pitches.
Yes.
Potentially, and it's not a big issue, but potentially if you were putting forward several pitches together or half a dozen pitches together, I would suggest that some of those facilities could be shared facilities.
Oh,
and
absolutely.
therefore you may be suitable on smaller sites.
Yeah.
And I think some of the permissions permitted more recently on site have had shared utility buildings or shared amenity.
I'm sharing buildings
So,
and
I think the more
presumably,
pitches you put together, the less 500 becomes a minimum for each one.
yes, well, that's obviously logical. And the same thing is you might not be, you might have a waste management system for 4 or 5 rather than just for 1.
Yeah.
Anyway, but the point is, there's been no reason for refusal. Nothing turns on that policy in this case,
No.
does it? No. Okay, and then we went to planning policy for traveller sites. Okay, and you've set that out. Well, we're going to look at that individually, so I'm not going to go there for the moment. I'm going to go therefore to your paragraph 39.
This is 539.
Sorry, no,
No,
my fault. No, your page 39.
Oh,
Okay, where you set out the list of things in issue, really. You're 1 to 10.
yeah, I call them the material considerations
Okay.
of the following issues.
Yeah. Well, that's good. 1, 2, 3, and 4 follow the reasons for refusal, don't they? Character, overdominance, protected species, and no information on flooding.
Yes, and
Okay,
the clue or confirmation is my RR1, RR2 in brackets, which
okay, and then,
I
and
haven't
then, and then
explained, but
you,
is reason for refusal.
sorry, thank you. And then you added in what you thought additionally in your proof of evidence at the time were issues that were material considerations for the inspector to consider, yes?
Yes.
And then we got them cumulative impacts, difference between the sites. Come back to that very briefly now. What do you mean by that?
It's an issue which I think has been picked up and explained more recently by Ian Dudley. I obviously didn't have the benefit of, might have had the benefit of his comments at the time I wrote this, but the cumulative impacts is basically whether there is a multiplier effect by considering several sites together. And the most obvious example being someone like Ian Dudley and the impact on the landscape.
Not a reason for refusal, was it? And there's nothing in the policy we just read out that talks about a limitation on the number of sites.
There wasn't a reason for refusal, and given each site was an individual application, then it would be, and I can't remember the dates of all the individual applications, it would be potentially difficult for those to consider the cumulative impacts, but it is something which I think is a relevant consideration.
I'm having problems with that. I mean, the only reason these 3-4 sites are listed together is the convenience of pins. So you couldn't have run this if each of these sites were determined individually, could you? So why should it be an issue?
If the 4 sites were crudely before 4 different inspectors at 4 different times, it would be difficult to do it. I'm trying to think there is an appeal decision where an inspector picks up on it, but I can't top of my head
You see,
think which it is.
but the general principle is that the inspector must deal with the planning merits for each site individually.
Yes.
Okay, certainly not take the view, but because there are 4, sometime in some way the harm is greater, and therefore make that a planning, make that into a material consideration. My view is that that would be improper. What's your view?
I want to. The elephant in the room on that, so let's brace it, is whether the issue of precedent is relevant
Four
or
elephants?
whatever. And I don't think it is an issue of precedent. So let's say I don't think it's an issue of precedent, but it is an issue potentially that if you go north of the track with 2 sites and being very obviously with a gap between them, that is potentially a precedent. But the more important thing is if you've got two sites, and sorry, I'm lumping here site 2 together with the 4 pitch, so it's 5 pitches, but the 4 sites on the site to the right, pitch 1, pitch 2, C and D, you've got 2 long strips of land with a fairly narrow strip not developed in between. Whether taking those together, they have a greater consequence than one of them would individually.
But you see, that's not what that says. I mean, if you're saying to me, the issue really is developing on the north side of the access road. What's the access road now being called?
Crocus Lane.
Lane, yeah. That, and the precedent that would create it, and because there's more than one site, it becomes an issue. I just said that isn't what you're saying there. That's a different issue. And in fact, that can be one pitch is enough to demonstrate that issue. There's no cumulative impact because you're drawing a line and saying we shouldn't go beyond that. So I'm suggesting that that isn't an appropriate issue, a material consideration.
I'm going to stay with that, given that the fact that this inspector is considering the 4 appeals together, a consideration is the effect of the four decisions.
Okay. Mr. Ward, I've explained my situation. I'm going to say I don't think you've explained your situation well, but of course I would say that. For the reasons I've said, it'll be a matter for the inspector between us. I'm not
Indeed.
going to spend time on it, okay? Bearing in mind the time we've got. So I'm going to move on. Intentional unauthorised development, I'm going to come back to that as an issue in a moment. general need. I'm not going to be spending time for the reasons we've already said on that because of Tuesday and whatever. So I'm going to move on from that. Personal circumstances and the best interests of the children. I will come back to that in a moment. In terms of the planning balance, I'm just going to ask you this for the moment on this, and I'll come back to it in a little bit more detail, possibly if I need to. In relation to the third and fourth reasons for refusal, the lack of information, we say, as you know, our case is that can be rectified by condition. Okay, so the issue between us, you nod your head. It would be helpful. I know the inspector probably
I'm sorry.
doesn't. He's looking down, won't see that nod. Just say yes. It would help me. Okay. No, you don't have to apologise. It's just I'm looking at you and the inspector, so I know the inspector.
Sorry, I
wouldn't
was
see that.
nodding because I was hearing your points.
Yes,
I
I know you
wasn't
were-
reading them as a question that needed an answer, but
I thought it was a yes anyway. I took the nod as a yes. Okay, but anyway, so let me go back to say that. So our case is that the lack of information, okay, can be dealt with by adequate conditions. Okay, we've got paragraph 28, which is new of the PPTS. Can we just look at that briefly together? I've asked you this question before about paragraph 28. I'm sure I have. That paragraph in the PPTS is very new. You won't find it in the previous versions. And it's the second sentence of paragraph 28. Shall I read it out? Local planning authorities should consider how they could overcome planning objections to particular process using planning conditions or planning obligations. So, and the purpose of that is local authorities were using, well, we don't have the information to refuse decisions, and government is saying, no, don't do that. If it's pretty obvious that that there is an issue, but it can be worked out by a proper condition, then that's sufficient. Do you agree with that?
I'm sorry, I'm not sure I understood the question. So
No,
it may be not
probably
listening, but
my phraseology. Okay, the problem identified by government is the local authorities were rejecting too many cases for lack of information, where in fact the problem could be dealt with by condition.
Understood.
Do you agree with that? That was the problem, and that's what this is trying to address.
I'm not sure if that's what it's trying to address, because I'm not sure if that was the problem from personal experience. So
Well,
if it's set out somewhere that that's what the problem was, I can imagine that that is probably
That's what
correct,
Mr.
but I
Woods is
can't
going to
endorse
say
it.
and has said on a number
Yeah.
of occasions. Okay, and it's typical here. We don't have enough information to make a decision, whereas the answer is, well, we're not proposing you need to have the information now. You can have the information in a condition, because the safeguard, isn't it, is that the person applying for development has to comply with the condition. If they don't comply with the condition, then planning commission won't go ahead.
Yeah, my hesitation only on that is that it is not dealing with development generally rather than gypsies, because I said I don't have enough background knowledge to know what the situation is in relation to gypsies. It is not uncommon and quite frequent for applications to be refused because of a lack of information, particularly these days relating to ecology. So that is a common scenario. And government advice to, in many cases, say applications should be refused if there isn't enough information. So it depends to what extent those issues can be addressed by a condition.
Well, the
I
government,
think long-standing advice in terms of any application is if there's an issue that can be addressed by a condition, the authority should give consideration to attaching that condition.
absolutely. The point I'm making, if I can, I just want to go back to it, okay, is that there's adequate safeguards here. Because if, for instance, in either protected species or the flooding issue, if we can't comply with the condition, perhaps taking the example of the flooding, because a modelling says that we need to do X, Y, and Z, and we can't do Z, Okay. But then the planning commission can't go ahead, can it? So there's more than enough safeguarding uh, um, built in to a situation where a condition determines whether or not it can be discharged.
I'm sorry if I'm being pedantic, but and some of this may be a discussion for conditions next week. But if you say if you cannot comply with the condition, the development cannot go ahead. In this case, on all 4 sites, the development has already gone ahead. So the safeguard
You are being
condition
pedantic.
is not to stop the harm that already exists.
Mr. Ward, you are being pedantic because we know that this is going to be that very difficultly worded condition that says planning permission will be granted, providing these things can be done. And if not, it won't be granted. So we know what the condition will say. You know what the conditions will say and the wording of it. So that is very pedantic.
Well,
the point is, I'm asking you.
It's a discussion for next week, but I make the point because the condition I've seen says development should not commence until the
Yeah.
development already
This is a
exists.
retrospective case, so it will be the retrospective permission that will actually take planning permission away if these things aren't done within a period of time.
That's not what's been drafted at the moment, but that's a
Well,
discussion for next week.
I didn't do the drafting.
Yeah.
Somebody will have to do that in the proper mechanism. All I'm asking you
But
about,
the
let me,
po- the
Mr. Ward, let
relevant
me just
point-
ask you the question, okay? All I'm asking you about is a condition can be worded sufficiently to create the safeguards I'm referring to, can't they?
Well, my answer earlier is I have concerns and reiterate my concerns, whether a condition can be adequately worded to do that.
Well, okay, that'll be a matter for the inspector. We say that it can. And we say that this isn't rocket science and this shouldn't have stopped this case. I mean, whether or not it's required in circumstances where there are no listed species actually endangered here is an issue not for you and for me, because we've already heard all the evidence on that. I'm not going to go over that with you, okay? And again, I'm not going to go over the flooding evidence on this because we've heard this about in great detail and we've gone into the conditions and there are draft conditions and amended conditions that are coming. Okay, so let me then having set out the various things, go a little bit further. Your 48, you deal with reason 1, okay, which is the character reason.
Sorry, this
You're
is
page 40.
Page 40.
Yeah. So, what you then, having listed the reasons, you then go through them.
Yep.
Okay. With respect, there's no point in us, although you did address it in chief, going through the impact on the character inference for lots of reasons. 1, because that's already been done. 2, because at the end of the day, it will be a judgment for the inspector. Okay. I just want to pause briefly. Okay. The inspector has, we know, the thatched farm planning permission, doesn't he?
Yeah. Yes.
Have the conditions attached to it. It's one point of clarity. That's a farm that operates as a brewery.
I've read the decision. I think I'm not an expert. I think it's referred to as a microbrewery, but
A microbrewery.
it brews something.
Yeah. A craft brewery, thank you. The 3 large buildings that have been attached to that, they're connected with the, not with the farm, but with the brewing side of things, aren't they? That's my understanding. If you don't
That's
know,
my understanding as well.
yeah, okay. So it's obviously a successful business that's expanding, and this is something that they're doing. Okay. Do you accept the visual impact those 3 buildings have on the AGLV? Is a material consideration here?
So yes, in terms of the first question, do I accept the impact they have? Of course, they have an impact on the AGLV. In terms of the way they've been considered and talked about, and it's not in my evidence anywhere, but in terms it's been talked about by others. I think it was Mr. Rowe. I think Mr. Dudley agreed with him, who suggested that they had the appearance of farm buildings as large tin sheds I'm
Yeah,
sure they
well-
use better language than that, but crudely large tin sheds are not dissimilar to
Okay,
farm
well, I mean,
buildings or whatever.
When the inspector,
Um,
sorry, when the inspector goes on site, he'll see the buildings. If you've been on site, and I have, you can see them. I mean, I didn't imagine you won't be able to see that something's changed since the last year that I was there. You might have to stand on the fence. But anyway, so he'll form his own judgment about that, and we can come back to it. Conditional consent.
I accept, the answer to your question is I accept they have an impact
Yeah.
and that is a consideration
Yeah.
for the inspector.
And
But
again,
others have given evidence on that issue.
yeah, I know. Again, in relation to that impact, that was dealt with dealt with by conditional consent, wasn't it? In relation to those buildings. There were conditions imposed.
There were conditions attached. I'd be surprised if there weren't.
No,
So,
well, there
but yes,
always
there
is
were
now, yeah.
conditions
Okay.
attached to that decision.
Okay, so let's move on, because I'm not going to linger on these things. We then come to the what you euphemistically call the impact of development on the settled community, but that's not actually what it says in the reason for refusal. It refers to let's get the wording correctly. It refers to domination. Okay,
Okay.
so let's just look at that as a topic between us if we can for the moment. Could you pick up paragraph, sorry, the PPTS and paragraph C?
PPG.
The PPTS, sir, and
PPT
paragraph C. Sorry, sir, did my voice dropped down? I
That's okay.
apologise. Just pausing, Mr. Ward, just for a second. And Mr. Ward, it's probably a good idea, and I have to open my to get up the appeal decision of is it Gilbert or Gilbert?
Gilbert's.
Gilbert, thank you.
Inspector Gilbert.
Because I'm going to ask you about paragraph 22. Okay,
So that's at 3A.8.
I've got a hard copy, so I think it'll be quicker.
but I'm just. Are you ready? Then tell me when you are.
I have it in front of me.
Okay.
What paragraph?
I'm going to take you to paragraph 22. It's the section where she deals with this, okay?
Mr. Masters, I've got them both online, but I can't see them together. So where are you going first?
I'm going to go to the PPTS first.
Yeah,
sir.
that's what I've got up. Good.
Thank you. I just thought, sir, if I flagged them both up, that would be of assistance. Okay, I won't do that. What I'm going to start with, Mr. Ward, is that paragraph 14 has always been a difficult and rather controversial policy. Okay, because of issues of equality and discrimination. So, do you accept that the way that one looks at that policy, and it is a policy, and one has to also consider how it applies in terms of the Equalities Act and the Public Sector Equality Duty at 149 of the Act?
Sorry, yes.
You do. Do you accept that the way you look at that policy and how it applies, you have to actually consider Article 14 of the European Convention of Human Rights? That's the not discriminate in terms of policy.
I certainly have no reason to disagree. So
Okay, let's look at what it says then in that context, if I may, because and see if we can break it down a little. When assessing the suitability of sites in rural and semi-rural settings, local planning authorities should ensure that the scale, perhaps we should underline the word scale, of such sites, and by that they're referring to gypsy and traveller sites, do not dominate the nearest settled community, Settled by that they mean non-traveller sites, don't they?
Yes.
Can you tell me where in any policy there's a policy that operates in the other way? That says
So
settled.
if I understand
that
your
said- that-
question,
yeah,
you're
that
saying
says-
whether there's a policy that says a traditional market housing site should not dominate a gypsy community?
Yes,
No,
there isn't, is there?
no.
And that's the problem, but by which we bring up, and we have to look at this policy in the context of, because one has to ask themselves whether or not this policy operates in an equal way among the community, and why is it that there is a policy restricting the number of gypsy sites that can exist in relation to a settled population. And I would suggest to you that that's not how this policy has been seen to operate, and other factors have been usually taken into account, but we'll come to that in a moment. Clearly, if we go to paragraph 22, so if I could ask you to go there.
So,
Yes,
sorry, is that of the Gilbert decision?
yes,
Like so,
but we'll come back to the PPGS in a moment,
to keep it there.
so keep it there. What she said, what she finds, paragraph 22, is she doesn't look at the issue of public sector equality duty or Article 14 at all, does she? She doesn't pose herself the questions of a public sector equality duty and how you should properly interpret this section. She just simply doesn't do that, does she?
Well, certainly not explicitly in the words on the page, no.
No. And then she says,
Whether she refers to it elsewhere in the decision, I'd need to read the rest of the decision. but-
yeah, then she says, there are no opportunities available to the appellant for further pitches within Lydia Park. Proposed allocations within the emerging local plan part 2 site allocations would extend and intensify sites within the borough. This does not alter my concerns about the numerical and spatial effect of the settled community. So she bases her concern, it seems, only on numbers and size. She doesn't address effect, does she? She doesn't then analyze whether or not those numbers or the size will have an effect that in some way would dominate the nearest settled community.
Well, she does.
No, forgive me, I'll say it again, and then you can disagree with me. But I understand you say she does, okay? So I'm not stopping you there. What I'm putting to you is that she bases that purely on numbers and scale, and numbers and size. What she doesn't address, okay, is how those numbers and size have an effect that would dominate the settled community. That's what I'm putting to you, is what she's done wrong.
Well, she sets out there the numbers and spatial effect, and the paragraph I looked at earlier, forgotten now which one it was, or it was a couple of the paragraphs, explained why she considered the spatial effect and the difference. She almost disregarded the issue of numbers and focused instead on the spatial effects of a site to the north of the access road, and in that case a corner site, and the spatial effect of an infill site to the south
Well,
of the
Mr. Ward,
access road.
I've noticed when you gave your evidence on this, you didn't refer to the numbers, you only referred to the spatial effect. Well, I've ignored that because I'm
Well,
correcting.
the
No, let me
inspector
just-
said this is 4 pitches, and I noticed there's other pitches elsewhere.
Yeah, but
And
she
the
then went
numbers
on,
was a less significant.
but she then went on in the last thing to actually says, this does not alter my concern about numbers and size on the settled community. What I'm saying that she has erred on there is that she hasn't addressed how numbers and size, okay, would have an effect that would lawfully entitled her to reject this application, bearing in mind the public sector equality duty and Article 4 of the convention. That's what I'm saying to you, that she's failed to do, because the way that, let me see if I can address it a different way. The wording of previous policies have looked at things like the effect that a development of that scale would have on local services, educational facilities, medical facilities. That's how it used to be addressed. Okay, the provision of those facilities and whether the numbers and the scale would have an effect on that. And I can understand that being relevant because it goes to the effect that those numbers and that scale will have and against a settled community that has limited facilities in the first place. But there's been no evidence here at all, has there, about how the numbers or the scale here would have any effect on provision of services of medical facilities or anything for any settled community that's already pre-existing. There's no evidence you presented about that, is there?
Sorry, so when you say no evidence here, you mean to this inquiry?
Yes.
Sorry, I thought you were still referring to Inspector Gilbert in that inquiry.
Good try, but you know I wasn't.
Well,
Could you answer the question?
Well, no, because
Okay,
I didn't think
understand.
we'd moved away from
Yeah.
Inspector Gilbert.
Yeah.
My answer is, and reiterating earlier, paragraphs 13 and 20, I think do deal with the spatial element of that. So the spatial element potentially equates to the word of scale of such sites in paragraph 14, policy C.
You present no evidence, Mr. Ward, do you? So we can be clear about this.
In terms of
as to
answering
the
your other
effect-
question,
Let me just
I
finish,
don't
please.
think there is, and I've said in my evidence, I don't think there is any impact on Dunsfold or Cranley, and in that extent, medical, education, health facilities or whatever. That's certainly not part of the council's case.
No, you don't present any evidence that the increase in size or scale will have any effect on provision of any services whatsoever, do you?
Well, that's deliberate. I don't think there is an effect, and I've
No,
said in
exactly,
the evidence there
exactly.
isn't.
Mr. Ward's been quite clear on that on a number of occasions.
He has to. So what I'm suggesting to you is that when the inspector approaches this, he has to be mindful, in my respectful submission, not only of what the wording says, but what it means in terms of a tangible effect. And there's no evidence here that you presented of any tangible effect. And the mere increase in numbers, I say, would offend against a public sector equality duty. It would mean that a policy operates unequally because it doesn't operate that way going in the reverse.
Well, I'm sorry. I think the evidence is there from Inspector Gilbert setting the example of the spatial effects of that development in where it is. It clearly also moves into other reasons or other issues like landscape, AONBs or national landscapes now, etc. But she takes the view or analyses the spatial effect on there. And I think that is the approach the council is following.
Yeah, and
I suspect you're not going to agree on this.
No, we're
point.
not, sir. I was going to move on
Yeah.
almost immediately.
I
I've
think that would
set
be a good
my
idea.
case out, and I think we know the case. We're not going to agree, but just so for clarity. So I've set out to you why I say Inspector Gilbert has erred, okay, but she hasn't addressed what the policy is really trying to achieve and interpreted in a way that would be acceptable. Because if the policy of the way that it operates offends against the public sector equality duty, it's the duty of an inspector to interpret it in a way that it won't offend against that duty, doesn't she?
I think the answer to that is probably yes, but that's got to be in the context too
That's very fair of you, Mr.
of
Ward.
other considerations that also need to be balanced.
Okay, Mr. Ward, that's very fair of you. Thank you. So I'm going to move on from there. I think by now you can see what I'm trying to do is just to set out where we differ. I'm not trying to get you to
Understood.
agree, okay, so that we understand our positions. And then just on the other point of this, if I may go to domination. I said to you that the policy doesn't operate in the different way. No one's considered, have they? But it's an appropriate reason to look at the scale of the 1,800 new houses at Dunsfold Aerodrome in the context of its impact on the nearest settled on Lydia Park. That's just not been considered, is it?
That's not true because it has been considered, because I've referred to it and I've referred to an appeal decision that addresses that issue.
Okay, sorry, not in terms of a similarly worded reversed policy as policy C in paragraph 14 of the PPTS, which is the point.
And again, to clarify, so in terms of Dunsfold Aerodrome hasn't, or consideration of allocation of those houses at Dunsfold hasn't considered what impact that might have on
Yes.
Lydia Park.
Yeah.
I will agree. I don't think
Well,
I've seen anything that
not
does.
only has it not done that, it's actually tried to exclude Lydia Park by blocking up the road so that the gypsies can't travel down to the services at Lydia Park, because that road is, and we heard complaints from quite a
don't-
few, let me just finish. We heard complaints from quite a few of the
Mr. Masters, I think you're straying on things up before the inquiry. We know the road's blocked.
Yeah.
I don't think there's anything to say why it was blocked.
Well, if you remember, sir, that some of the parish councillors were opposing that blocking because it meant that the settled community in Lydia Park wouldn't have access to those
Yes,
facilities.
but you're going beyond that. You're saying it was done for a specific reason. I don't think that's before the inquiry.
No, I probably overstated that, sir.
Yes, I think so.
And I go back on that then, I'm grateful. No consideration was given for the benefits to that development, but could be achieved by keeping that road open for the settled community and for the travelling community. And I say that's a greater planning harm than anything that arises in policy C.
The honest answer is simply I don't know, because I
No, I
don't
know
know
that.
what consideration has been given to that road.
I have to ask somebody
However,
about the question, Mr. Wall, so I can make a submission on it. So you're the one.
The obvious point, I think, for the inspector to consider is if Dunsfold Park did have an impact by closing that road, it had a similar impact on the settled community, and there was not discrimination for that reason.
But it's my example of why the policy
Understood.
is working in reverse in a way that discriminates against gypsies and travellers. Do you see? And I think it's a very good example. Okay, I'm not going to ask you any questions about which you go to at 52, lack of information on the protected species. But you heard the wood white butterfly is actually not a protected species. We heard that yesterday.
I think it was the phrase a priority species. I've read the Mr. Sibbert's proof.
Yep, not a protected species though. And I'm not going to ask any questions on flooding for those reasons which you then go on to next. Intentional unauthorized development then, this is your 58. Page 58, your section 7. Standard question. Does the 1990 Town and Country Planning Act allow for retrospective planning permissions to be made?
Yes.
Intentional unauthorized development, okay, means unauthorized development. It doesn't mean criminal development, does it?
No.
There have been though, history in this case in relation to these particular sites of lots of previous applications for development that have been refused, and then they've continued to develop, have they?
So lots of applications that have been refused, and
Yeah,
then
they've continued to develop. This is their one and only chance to see if they can get a retrospective planning application.
to the first part of the question, I suspect that's the case, but don't think categorically I know that there's been applications where people have then carried
There-
on.
there
I
was a-
suspect
but-
that's
but-
probably the case.
But there's been 2 planning applications in relation to C&D, because there was one put in by Mr Brown in 21, and then that was withdrawn, I think, for validation reasons.
Oh, sorry,
but it
in
was
that
for-
sense, yes, I know there were prior, sorry,
Yeah.
I thought you meant elsewhere in Lydia Park. or
Oh, no,
whatever.
no, I was just talking about
Okay.
again, I was just focusing on the 3 sites I represent, not generally.
No,
Okay.
well, there was a prior application certainly for the 4 pitches,
but
of
there's no
pitch 1,
hist-
pitch 2, C and
There's no
D.
there's no history of a flagrant attempt to move the system by continuing to make applications where applications have been refused. We're not in that type of criteria, are we?
Not that I'm aware of.
No. Okay. We also know that, and I'll put this to you, at the present time, okay, this local authority has no sites to meet the need of the 3 applicants I represent, do they?
When you say the authority has no, in terms of a public site,
Yeah,
no.
they have no allocated sites to meet the current need of those, so they could direct them to develop, do they? At
Well,
the present time.
I referred to various allocated sites, so those sites exist as far as I know and are potentially available. But in terms of could the authority move them onto those sites? They're not in public ownership.
Right, not available, that's fine. So we have a situation where, although you think you might have a 5-year supply in the next 5 years to meet the needs, you can't meet the need right now, can you?
Well, no,
And the PPTS no, I take that as your answer, but the PPS talks in the context of this, of need being a relevant consideration for the inspector.
before we move on, because you say you took my answer on that, I don't think I've given an answer on that, so just bear with me
Well,
for a moment.
Then please give the caveat.
The other thing is, Mr Masters, I don't want you going into need and supply.
No, I know, I wasn't going to go to it in any great
mean-
extent, so it was just, if I'm straying into it, then I won't.
Right. Inspector, I really don't want to interrupt my learned friend. The only concern I have is that you've given a very clear indication in terms of when proceedings end today at 5. And
Yes,
so I know my learned friend said, I think that he would be an hour.
an hour, I think you said an hour and a half. Mr.
Yeah, so
Clinton.
I'm just saying that we got to that.
I don't think I'm
stage.
an hour and a half yet, am I?
Need 10 minutes.
10 minutes, yeah.
Okay,
I'm-
yeah, because I'm just slightly
Yeah,
worried about
I'm,
timing.
as you can see, sir, I'm moving as fast as I can. I haven't been delayed or anything. I felt that I'm doing rather well, I think.
But I do think we can leave need and supply.
Mr. Mr.
Tuesday.
Ward, let's just leave this, because I
Okay.
think the inspector's right. We'll just leave this as an issue, and we'll come back to it later on. Okay. And it's my fault, not yours, by the way, but we went there. It says we don't need to go there on my little note, but there we go, I'm enthusiastic. Okay, and then general need you deal with at 61. We're not going to go to that because we know we're going to deal with that tomorrow. So all that section. And we then come to personal circumstances at 65. But the reality of that is, at the end of the day, that's going to be an issue for the inspector. That will go to the issue about whether this is a personal, if the inspector finds that personal circumstances are pivotal, okay, that'll mean he can impose a personal permission if he wants to for these particular families,
Yes,
okay?
and at that point, personal needs would be a consideration.
Yeah, and there is, I listened very carefully to your counsel, and there were very, very few, well, in fact, in most instances, just one question about personal needs. He didn't dispute anything. You don't dispute the personal need evidence, do you?
No, well, we heard much of that yesterday. I don't think there's any question that now all of the applicants, and obviously it varies from family to family, but have fairly significant needs.
Okay.
greater in certain cases.
Just on the terms of best interests of the children and a point you made about flooding issues, okay? A point that was raised when they gave their evidence on this, okay? And I'm not going to go back over flooding evidence. You're not a flooding witness, and there's a difference between us. There's no evidence on flooding depths, on flooding velocity, on how long any flooding will last for, or matters of that sort. Okay, we'll address that in the flooding evidence. Okay, but you say, well, because there's uncertainty over flooding, that would be a reason. It would be in their best interest not to be on site. That's where you put it, isn't it?
No, what I put, I hope, is that because of the evidence of Mr. Smythe, which says that there is a considerable flood risk, and certainly I think in his written submissions, but certainly in chief, he was asked to quantify the likely depths of flood water, the risk to people. His evidence to the inspector that was a severe risk.
Yeah, and that's challenged.
So well, it's challenged,
Yeah,
but
and-
you said there's no evidence.
Well,
there is evidence.
There's evidence for Mr. Smythe, but what I didn't say there was no evidence. What I said to you, there was no evidence about depth. There's no evidence about velocity. There's no evidence about how long.
Well, that's certainly not accepted, Alan, because that he gives figures for depth things in his rebuttal and things. And so, I mean, I think it's best left for the inspector's note and the evidence as to what the evidence is.
Well, you can say, well, it's not for you to answer. It's for you to answer. So,
Well, my answer was Mr. Smythe did put that
Yeah,
evidence, and if you,
you've heard that
in
from Mr.
terms of
Lintoff now,
that,
yeah.
he did
Okay.
mention
Well-
depth. I can't remember him mentioning.
I don't think
velocity.
when the inspector asked him these
He
questions,
did go into issues of, I think the phrase was 3/4 of a ton of flood water,
Yeah.
which I tried to get my head around the meaning of that. But he did give various quantitative evidence in terms of what the
Well,
scale of that problem would be.
Okay, I'm going to put my question to you.
I think this
right
is
now.
better left to closing because we're not going to agree on this. There's three different reasons. There's the planning authority's point of view, there's my learned friend Mr. Masters' point of view, and there's my point of view, which I thought I touched on in cross-examination with Smythe, which that modelling was required to give an accurate figure, and Mr. Smythe was basing it on the unmanaged situation without a culvert, without
Yeah.
it.
Well, I'm putting,
Mr. Smythe nevertheless gave a view.
he
and
did,
it-
sir.
and-
I
and
accept
that-
that. And so
Well, that has to be taken into account in terms of the context in which it was given,
Yes.
but yes,
and
there was information given on behalf of the local planning authority.
You then clarified that, so but I'm not going to get what I'm going to suggest to you is that the alternative is that these families will be on the road. Okay, there isn't any accommodation. Okay, you heard that these two of them came to this local authority to seek alternative accommodation, and were basically left with the "well, get on the road" argument. Okay, and I suggest to you that on any balance of best interests of the children, being on a safe site, which they don't need to go, particularly C and D, who won't flood at all, and A, although it might flood, it won't affect them because of the height of the mobiles, is far preferable than them being exposed to the dangers of being on the road on a daily basis. We've heard, for instance, particularly in terms of Tom, how dangerous that would be without electricity and all the things that he needs to keep himself and his brother safe. So I'm suggesting to you that your opinion that being on the road is better can't be right.
My opinion isn't necessarily that being on the road is better, and it's an issue for discussion when we deal with need. But I reject the idea that there are no sites to go to. And the evidence I put for that, and to discuss next week, is the appendix we already discussed partly already, but is in terms of, I think it was CW16 at that time, is now CW16B, is, I haven't read it recently because it's not Tuesday yet, but there's something like 28 potentially vacant pitches at Lydia Park.
Okay, so your evidence is predicated on the basis there's some alternative accommodation safe accommodation that they can go to. Let me put it a different way. Is that right?
Certainly, I think there is potentially alternative
That's
accommodation
what,
available.
that's what your opinion was predicated on. So if the inspector comes to the conclusion that there isn't, he rejects your argument, these are available, and the only alternative is the road, do you accept it's safe for them to stay on the site?
The issue, I think the inspector then
Could you
needs,
answer the question, Mr. Ward, first, and then you could put your caveat, please?
I think there's a predicator there that the alternative is only to go roadside.
Yeah, and that's where I put it to you. And on that
Yeah,
basis,
if the only alternative to go roadside, that alternative needs to be considered against the flooding evidence.
yeah, that's what I put to you. You,
To my mind,
in that instance,
as not an expert on flooding and not making a decision on flooding, I think the flood risks tip against them staying on site.
so
But that's a
even
decision the
if they're
inspector will
even if
come to.
they're going to be on the road, you still
Yes.
say their best interest is being on the road.
Potentially, yes.
Well, yes or no?
Yes.
Thank you. Obviously, we disagree, but at least the inspector I say that.
I don't think that scenario will arise, but we'll deal with that next week.
Well, we will indeed. Okay, thank you. And lastly, on temporary planning permission. If the inspector comes to the conclusion that, and it was a position put by Mr. Cottle, that there needs to be a condition which involves modelling of the position relating to the locking up of the culverts, and a remediation scheme following that. Okay. One alternative he would have would be to grant a temporary permission while that works out. What would you say if the inspector came to that view would be an appropriate time?
Here I am having to think about the time period of others, not least or primarily, and I'm going to say to the inspector, it's not in evidence because it's information I have from Mr. Smythe in relation to other appeals, which relate to the time that modelling can take to do. So it's not a case of how Mr. Cottrell is going to put it.
Just
But
give your
it's
time.
not something
Mr.
where the inspector can
Okay,
say
Mr.
subject to modelling within 28 days because it probably couldn't be done in
No.
28
So what's an
days.
appropriate time, do you think?
If it's essential to go through, and it may be a discussion we need to bring Mr. Smythe into on conditions, that if the inspector wants a condition that allows for modelling, it is probably going to be a minimum of 6 months.
Okay.
If there is then a time period for implication, the application, and if we've modelled something and decided what's necessary and how long it takes to do it, you're probably into 12 months.
Okay, thank you. I've no further questions.
Thank you, Mr. Masters.
I think I'm kept to my time, sir. But I did actually say about an hour and a half. I didn't actually stick with that.
No, I've been keeping a check and I know where you're up to, Mr. Masters. Yes, it's on time. It's just that we are tight anyway.
Oh, no, I know. What's wrong? I don't know.
10 to 1, I'm going to take the lunch adjournment now. I'm going to be looking for a shorter adjournment if the parties can accommodate that.
Can we have at least 45 minutes, sir? Because we've got to get
No,
something to it.
I don't think there's, I'm not,
Inspector, could Mr. Cottle give us an indication based upon Mr. Masters' cross-examination of how long he expects to be?
I would like to be less than an hour.
well, I was thinking of suggesting only 25 minutes today for lunch. I know that's tight. That would be, you'd be finishing your questions at 2:15, which is very difficult.
Just doesn't give us
But I
time.
can't see how I can bring it any forward any more than that.
How long are, I mean, because we haven't got any written estimates, but how long are Mr. Cottle and Mr. Masters intending to be in chief with Mr. Woods?
I think I already said so, hadn't I?
Can you just remind me?
I thought I said about an hour and a half, but I think I'll be quicker than that.
You did, and it was an hour and a half, and I think half an hour from Mr. Cottle.
Yeah, I think I'll probably be quicker than that, so I think I'll be under an hour.
I think
can have my microphone. It is important that Mr. Woods gets across the points on behalf of his clients, but it may be that during cross-examination, you will have picked up the trajectory of our case and you will know already what our case is. And I don't need to go over the points that we've been cross-examining on. And so I can be quicker.
it may be that there is some scope on the morning sessions next week to, if we were to overrun in terms of dealing with the planning witnesses today. I don't know about Tuesday morning, but I would have thought we may not need a full morning session on conditions. I think that's,
We could, you're suggesting, Inspector, maybe pushing things back a little bit and having the site view maybe on the morning of the Wednesday and then having the conditions maybe later in the afternoon on the Tuesday. So,
well, there are various ways of possibly doing it. To avoid minimising the disruption would be to hold, if Mr. Woods is started but not finished, would be to hold him over to Wednesday morning, which I don't know what his arrangements are, but that would be one option. The other one would be to shuffle things around a bit more. I'm reluctant to move Tuesday morning because Councillor Stone, who's not here, I think will be committed to that, and I don't think that would be, and Mr. Jarman. So I think we need to keep that, but we could. The other option would be yes to push the site visits back and get Mr. Woods back on a Monday afternoon.
the Tuesday afternoon, yeah.
Sorry, Tuesday. Yeah, I'm falling into Mr. Masters' trap now.
There's always the option of closing submissions on another day in writing.
Well, that's the ultimate fallback, isn't it? I
yes.
suppose we don't
There
want
is
that,
that.
but there is
Yeah.
that option, yeah. Well, Inspector, can we all thank you and take you up on your short lunch break and
I know, but I think we need to. I think we really do. I'm prepared to go for half an hour.
okay, Inspector.
So we'll adjourn, resume at 1:25, please.